morning. Sorry, I have my obscene phone call breather right beside me today. I'm not sure what's up with my doggos, but they are being a little unruly this morning. So we'll let old girl stay with me for a little bit until she gets annoyed. Anyway, I am Alternate Juror. Welcome to my channel. I am glad you're here. Happy Monday. Almost forgot to say that. Mondays can be happy sometimes. I apologize if you can hear. Hello, Gabby. And Stormy. What am I supposed to do now that I cannot ask you how the weather is? You can have some of our rain because we keep having a ton. Not flooding, just a little annoying. Just a touch. I hope you all had a good weekend. And I hope you have a good week. All my appointments are done, so everything that kind of got screwy last week is over. I hope. Nobody has called me to. She just got my coat all dirty. Thanks. Nobody's called me to say anything different. Yes, I'll take that now. So we are going to jump back into the last 5 minutes. Told you. The last 5 minutes of what we were watching Friday. It's the eyewitness testimony in the Lamar Johnson hearings. It gets a little heated here at the end is the only reason I'm going to watch it because I was just going to do a quick recap on it, but he gets a little heated there. And so it's interesting. Then we'll jump into the next day, which is part 2 of this day that we're watching. It's an audio mess. we're gonna jump a lot because they're great. They're great. Yes, it's been that kind of morning with them. They've been testy with each other a little bit, so that's also why I'm allowing them to come in and out. But if they don't knock it off, they're just gonna stay out. Anyway, apparently in the next day that we're going to watch, it's the camera just goes off. It goes off about 3 minutes into this witness testimony, so he's still doing like all his I went to school for 1,000 years and I have all these awards and hours and everything testimony. We're not even going to bother with that. I'm just going to skip because it goes off for about 15 minutes or so, give or take 14, whatever. And then the judge comes back and he is speaking, and apparently there has been a pew pew has powed in the somewhere. I don't know. We never hear because they come back with the judge speaking about it, and that if anybody doesn't want to sit by windows or something, I don't know. It's crazy. And then the next witness comes on and he testifies for a little bit and then he just freezes. The whole thing just freezes for an hour. Can't hear him. It's just a spinny circle. So then we'll come back when he unfreezes, and then you'll see that the whoever's running the audio for that channel, you'll see their cursor go across the screen and click. And I'm like, are you unmuting? I know all about that. So it's nuts. And I believe that day ends with the prosecutor, and then the prosecutor the one that originally tried this case, he is now speaking for Mr. Johnson. He's the one that we're going to end with, and then start the following day, so day 3 with him. And those videos, for whatever reason, are broke up into 3. So I have them all in order. And I don't know where this channel got their audio people, but They're not great. And I am not really complaining because I can't say a word. I'm really great at muting myself. I'm awesome about it. All right. So let's hear the last few minutes of Mr. Elkins. Remember, he was the eyewitness who has recanted his statements that he made during the trial. He is feeling guilty because he feels as his testimony helped put Mr. Johnson in prison with a life without parole sentence. He has recanted everything. He is here testifying on Mr. Lamar Johnson's behalf. And obviously, the state doesn't like that. And that is who is questioning him now. She is going to ask him about the night of October 3rd, about what he saw, who he said he saw at the time, and who he is saying now he's just saying, I don't know who it was. There was no way for me to tell. So him and the judge have a little back and forth. The judge is going to get mad, and sorry, I had my hair fixed. It's the dog's fault. That's what I'm gonna say. So we'll just watch this and then go on to the next one. And I am very, very interested in what the prosecutor has to say and what when the state gets to put on their side, what the detective has to say. Because those are two people that work together who are not working together anymore when it comes to, well, probably aren't working together because they're probably retired, but aren't working together anymore to keep somebody in jail or in prison. One's working to keep him there, the other one's working to get him out. All right, I've got everything boosted, turned up, all that good stuff. I haven't touched anything since Friday. And remember, the state is allergic to microphones.
Yeah.
And so going back, I just want to make sure I understand this timeline correctly, Mr. Elkins. So October 30th, 1994, that's the day the lead was forget there. That's whenever you witnessed your friend get murdered.
Yeah.
And on November 3rd in the afternoon, you looked at some photographs with Detective Nickerson.
Yes.
Is that fair? And you at least recognized something familiar about the eyes in one of those photos.
Yes.
And on November 3rd, that night, you looked at in-person lineups, correct?
Yes.
Hello, George. And on July 11th of 1995, you testified at Lamar Johnson's trial.
Yes.
And you pointed to him in the courtroom and said, that's the person who grabbed me.
Yes.
And then...
Or for a moment. Lamar Johnson was the person who grabbed you.
No,
Because that was the question you were asked just now.
She just asked me if Lamar Johnson.
She asked you, was Lamar Johnson the person who grabbed you? You pointed in court and said Lamar Johnson was the person who grabbed you. And I just need to know if that's true.
You know, Your Honor, I guess I know I pointed to him. I pointed him out.
You don't recall saying, or tell me, do you recall, or if you said in court, Lamar Johnson was the person who grabbed you?
I guess I did because he went to prison. I mean,
Well,
you know, what I'm saying to you,
because there were two assailants, correct?
there were two assailants.
All right. Now, one of them was, as you said, wrestling with Mr. Boyd.
Yes.
And one of them grabbed you.
Right.
And are you saying Lamar Johnson is the one who grabbed you?
You know, I'm here to tell you that I don't know who grabbed me, but you know, if I said it back then you know, I was lying, I guess. Or
were you quoting from the record saying that Lamar Johnson is the one who grabbed me, or was that just a question?
That was my question, Your Honor, and I think I can clarify.
Yeah, you need to.
Whenever you identified Lamar Johnson as one of the assailants, we understand your testimony today, sir, but back in 1994, the person that you identified as Lamar Johnson,
was that the person who ran out to Marcus, or was the person who told you to get the fuck up?
It would have had to have been the guy that told me to get the fuck up, because that's,
Okay, and
That's the one whose eyes you were looking at, from what you told me earlier.
yeah, that's the one where it all got put forth that's
And that's the one you saw with the
And that's
9mm pointed at you.
and that's who the detectives told me and believed that it was. And so I believed it too.
very personally.
You may, Counselor.
Thank you. So I'm showing you portion of the trial transcript, which is in the book as State's Exhibit A. I'm showing you page 160.
Page 160.
Starting at line 4. And this is your answer. As Marcus was scooting back behind me, I kind of was still sitting on the porch, focusing on the one person that came up to me and told me to get the fuck up. Question. Now, was there anything unusual about that person's eyes? Answer. Yes, sir, there was. Question. What was that? Answer. The one eye was kind of lazy and he was staring right at me. Question. And do you see that person in the courtroom today? Answer. Yes, I do. Question. Would you point to him and say for the record what he's wearing today? Some off the record discussion, or some lawyer discussion, but then I'm going to page 161.
This is the trial transcript
That's
you're
correct,
reading
Your
from.
Honor. Answer. You asked, go ahead and point him out. Question. Point him out and describe what he's wearing right now. Answer. That man over there with the yellow shirt and tie on. Did I read that correctly?
Mm-hmm.
And so whenever you
Hold on, let me see if I got this correct. This is important. If the person who told you to get the F up, the same person who pulled your arm caused you to go down the steps.
And that is where we're at today, and that's why I'm here trying to explain
I
it
just
to
need
you.
to know what it is. You just think back in your mind.
I can't
Somebody
tell you.
tells you to get the F up.
And I can't say that that was him. What I am trying to tell
No,
you
that
is
wasn't
that,
my question. I don't care who it was. This human that said, get the F up.
right,
Was that the same person that you talked about somebody pulling on your arm?
I can't say that it was. I cannot say that it was.
So you don't know what this person who said get the F up did?
No,
after
because
he
I
said, "Get
don't
the F
know
up"?
who the shooters were.
No, I don't ask you who it was. I'm asking you just a shadow of people in all the black.
Yeah.
Forget who they are.
Okay,
Just think
Okay.
back on the individual who said to you, whoever it was,
right.
get the F up. Is that the same person who pulled your arm and caused you to be down the stairs where you left it on
Yes,
that picture
yes.
with the dot?
Yes, yes,
You're sure about that? I need you to be as sure as you can possibly be.
yes, because the only person that I would able to be closest to identify would be the person that was right in front of me, the one that did grab me. Okay, so that's how all this even got started, to where they thought that I seen more, or that I knew more, or that I, and the thing is that, Judge, I do not know who it was, and I just was told, and I was led to believe that it was Lamar Johnson.
All right, I need lead counsel for relator and lead counsel for respondent in my chamber. That's all I want. Period. Lead counsel for relator, lead counsel for
Do I have?
the respondent. You can remain seated, you can step down. You can step down. All right, we'll recess. I guess since I have to do a 12:25 hearing, I might as well recess an hour. So we'll recess an hour. All right, this.
So, Judge wasn't happy. He's mad about something. They recess for lunch, basically. So, we're going to catch it after lunch. Uh, I was thinking about this trial or this hearing yesterday when I was mowing, and I'm probably probably the only one that will remember this because I'm probably the only one that's old enough to remember this. Back in the day, there used to be a talk show on TV. Um, well, it used to be several talk shows. You had Oprah, and she's the main one. And then you had Donahue and Sally, Jesse, Raphael, whatever. So they would do their shows, and they'd have people up on the panel just asking, whatever questions, like they were interviewing them. And then the people in the audience, and then somebody would run out on stage and grab a woman's handbag or whatever. They would run out, grab it, and run off the stage. And the whole point of that was asking people in the audience what they saw. They hardly ever got it right, and nobody ever saw the same thing. Blue shirt, red shirt, white shirt. It didn't matter. He was, it was a black guy, it was a white guy, it was a Hispanic guy. It was they never got it. So I kind of understand this guy going, I don't know. And now we're talking 30 years ago. I can understand where he doesn't know. And he's trying to say, I don't know. I told them what they wanted to hear. He keeps trying to say that. And the judge isn't having it. And I understand. That why the judge is kind of like, I need to know what you're saying. And he's trying to tell the judge, I don't know. I don't know. I said what they wanted me to say back then. I'm telling you today, I didn't know then. I don't know now. Well, I did. I was going back a little further before it all went nuts. Before we had You Are the Father, Not the Father. Ricky Lake, I don't know what else she did. Whatever. And weird people fighting on Jerry Springer. Yes. I forgot them. Talk shows back in the day were the best. They were awesome. All right, so the judge is going to be. He just comes back. There's no closed captionings on here, so my apologies for them not putting closed captionings on this one. It's the second part of the day, so I'm hoping either they got their sound figured out because there is no closed captionings. But this is a judge after they just went blank for like 15 minutes, coming back and saying, apparently there was, things fired out of a thing.
An area not out to the street, but into a big covered area that nobody can shoot into those windows. However, there may be people out here who feel like they need to leave, so I thought I'd better let you know what I was just advised of. So I'll leave that to the people in the audience to make their decisions. Counsel, you may continue.
And I'm not talking about Dr. Colbert. We're comfortable proceeding, notwithstanding the gunshot, Your Honor.
All right.
We just got interrupted.
Same thing from the AG's office? All right.
How many times you hear that in a trial? Or good proceeding, notwithstanding that I shall not mention. So the only thing we missed was they called back the eyewitness that we were just watching. Nobody had any further questions for him. They chatted a little bit that you can't hear. The state was objecting to some things, and the judge was like, not the right time. There was some the witness on the stand we didn't get to hear very much of. So she's gone. And this witness we'll get to hear a lot of, and then I don't know if the gun or I mean the holy crap, if that thingy comes back again because then it freezes and we'll just fast forward through all these dumb things for this day. Uh yes, Stormy, I got it. I'll talk to you. I don't know that I'm comfortable. We'll talk. I froze it there. I paused it there just for you, George.
Your Honor, I think we have a very simple, if you've already made the finding, we certainly aren't going to interfere with that finding, and we will, I would agree that we don't need Dr. Cabrera to testify anymore. That being said, if you think that you haven't quite reached the point where you've made that finding, I'm more than happy to proceed quickly with Dr. Cabrera and have you cut me off if you'd like.
Let me see if there's any aspect that concerns me.
That's the witness that was on the stand that we didn't get to see because they
It
went.
would have been a better idea if you had asked me to let her listen to his entire testimony. Because there's a lot.
Mhm.
I have a whole list of reasons why I have questions concerning the reliability. What say you, the Attorney General's office?
Thank you, Judge. We would object to this witness first regarding relevance. The petitioner has shifted the facts in question. The testimony that you heard from James Elson was regarding that, according to him, officers told him to pick.
Mm-hmm.
If the court believes that, then it's not a question of how suggestive the lineup was. It was an officer telling him who to pick. So there's no fact at issue that this individual would have any relevant information on. Second, Judge, and as the court already pointed out, any testimony from an expert witness has to help the fact finder. Judge, we believe you don't need any help. You are well versed. You have the knowledge and the experience to review what occurred and come to your own decision. And third, Judge, it sounds like you're going to try to get into particularized testimony regarding eyewitness. So we would object to particularized testimony, even if the court allows her to testify, as she should be limited to general testimony on general practices and not particular testimony or particular facts in this case. And what I'm trying to get at, Judge, and I'm sure you're aware, she can't say that I reviewed this is specific. And I would direct the court to state the Carpenter, Missouri Supreme Court 2020 case 605, Southwest 3rd, 355.
I think I'm familiar with that case. You have a response to her?
Well, we would agree with that case too, because that was a case in which I believe it was, who was it? I forget which judge. It's Judge Wilson. Judge Wilson wrote it, and he said that eyewitness reliability expert testimony is admissible under Missouri law.
It is admissible, generally speaking.
Yeah.
But you got to understand the word admissible does not mean must be admitted. A whole bunch of stuff is admissible, but the sound discretion of the court might exclude it for any number of reasons. Now, in this particular case, this witness told me that when it came to those lineup photos, he went back because they basically suggested that the person that they think might have done it was in the picture.
Mhm.
He then picked somebody who, based upon their height and then this whole lazy eye thing,
Mhm.
that he thought might be the person, but he really wasn't sure it was the person. Well, that fits the definition of unreliable in-court ID. He also told me that in court, he ID'd the defendant because it's the only person that looked like a defendant sitting over at the defense table. Now, you don't need a PhD to nail that one down.
Yeah.
Right? Although I have a JD, but not quite the same.
Yes, I think we would definitely agree. The court, I think, is going to see both Mr. Moore.
And I've advised counsel for the Attorney General's office of my view on this, as you heard, as we did briefly in chamber. So I anticipate, number one, she doesn't necessarily have any cross-examination that can go into that. And number two, she no doubt realizes that that's a dead horse that we probably should let lie and move on to the more pertinent issues concerning this case.
And the only thing I would add on to what you just said, Your Honor, is that in that photo array on top of Mr. Johnson was also Mr. Campbell, who actually was the person who was on the steps holding the gun. And
See, I didn't know that until now.
exactly, that was one of the things that we were going to go into.
Yeah.
It wasn't
But
just.
you used to told me that.
Yeah, here, I'll show you, Your Honor. Just so you know.
Which number was Mr. Campbell?
It was the way it was arranged, there actually wasn't.
I'm gonna point to the person's Mr. Campbell.
So, Mr. Campbell, right there.
Oh,
You can
okay.
see Bill Campbell.
Oh, that's the guy who came in.
That's-
No, that's not the guy. That's the guy who's dead.
Yes, he's dead, and that was the gentleman who was actually holding the gun on the steps to Mr. Elking.
I got you.
Judge, I apologize, but just for the record, could you clarify what exhibit you're looking at? We should make sure you're explaining that.
Absolutely. This is Circuit Attorney's Exhibit 62, Your Honor.
And I think you admitted it as respondents W. And it is the bottom far left photograph with the number.
All right, so they're still talking about Mr. Elking's testimony about who he saw, who he says he saw, who he says he saw now, and then that's the photo lineup that he was shown, which the judge is like kind of not hard to see why he picked Mr. Johnson. I'm assuming he meant because he was a black guy. That is an assumption. I don't know. But that's where I thought the judge was kind of leaning. So they're arguing they're still talking about his testimony and what he saw. And I apologize. It's been that kind of day. I'll be right back after I start this.
Number 245651 in front of it. All right.
And that's Mr. Campbell.
Okay.
All right. From what you said, with apologies to Dr. Covera.
You cut a check, did you?
Yeah,
Not yet.
I didn't, Your Honor. No.
All right. Good.
We will make sure that she is definitely treated correctly for her crime. So, with
I like
apologies,
that,
Dr.
not
Covera, it sounds like.
Thank you, doctor. I have a quick question for you guys. Did only one person pled guilty, or the two people? Two people pled guilty.
Only one pled guilty, Bill Campbell.
So what now?
He was, remember, the first guy tried was Lamar Johnson.
Right.
July of '95. Then then the next year, in '96, when Mr. Elking stopped cooperating with the police, they made a deal with Mr. Campbell, the guy that he just pointed out to you. He pled guilty to manslaughter and got 7 years.
So we have two people who pled guilty to the crime. Am I correct?
One person, Your
Oh,
Honor.
one person pled guilty.
There's two people involved.
But only one person is a guilty verdict of any kind.
To a jury, yes, Your Honor.
Well, not necessarily to a jury. Let me make sure I'm
Well,
clear.
Judge, may I?
Yes, please.
Yes, absolutely, Judge. So the state of Missouri tried Lamar Johnson, as the board is well aware, jury found him guilty.
Right.
After that trial, Mr. Philip Campbell took a guilty plea, to which he said he committed the homicide with Lamar Johnson. I will tell the court, if allowed to present, evidence and information, we do have that guilty plea transcript.
So the gentleman who testified, I forgot his last name.
James Howard, Your Honor.
Mr. Howard has not pled guilty in this case.
Correct.
Correct.
All right.
His murder is a different case.
All right. Is he going to be charged?
That would be a question for the circuit attorney's office.
Is he going to be charged with the murder? Is he going to be charged? After what I just heard, it's being reviewed. Has this person, was that witness ever told anything about the possibility of being charged? Speak up, please.
First of all, Your Honor, based on the eyewitness, it's unlikely that we can charge anyone in this case. Based on the testimony.
Hold on, he said he did it. that doesn't take a jury a long time to deliberate on a defendant saying, yeah, I did it. So I just want to know, was that man ever talked to about the possibility of him being charged?
Based on the evidence, Your Honor, I'm still under review of that.
Okay, you're not answering my question. You need to answer it. Was that man ever talked to about the possibility of being charged? Well, somebody better get the answer to that question, Mr. Weiss. Your case depends on it. So give me an answer. You can call him. Actually, I can call him back. Deputy. Yeah, get that gentleman back in my courtroom at your first opportunity, please. And I'll just ask him directly.
Mr. Howard still here?
He should be. I say he shouldn't be released.
I think.
He should not have been released, because I was pretty clear about that one. Joseph? All right. Get him here. If he's on the road, tell him to turn the car around and come right back, because I did not release that man.
I believe he is talking about the inmate that we saw testify on the first day, because he said, keep him here. Don't take him back to prison. And it sounds like they took him back to prison, or maybe are taking him back to prison. That's why he said if they're on the road, turn them around.
You may continue.
Thank you, Your Honor. We have another witness. He's out of the courtroom. His name is Tony Box.
All right.
He's a former circuit attorney here. Just worked in the circuit attorney's office. Let me go get him.
I might want to ask this Tony person. Tony Box, did you say?
Anthony Box, B-O-X.
All right. I don't know if I've ever met Attorney Box before.
Oh, and he's not in the courtroom. They have to go find him. Be right back, Judge. But the judge keeps talking. Otherwise, I would go through this. It doesn't take very long. Just,
Oh, you're back. I thought we made him mad or something.
I feel
That's your call. I
Step
mean,
by
you and your boss's call. Yeah.
I know.
Oh no, I already knew that. Yeah.
There he is. They found him.
Now, if it was like a huge problem, right. And I've been right back. Oh, to get pictures. Oh, you're right. I had thought of that. First
Could have been
responders.
since they had that episode with the pew pew. I tell you, it gets better.
Nope. You may inquire.
Okay, thank you.
Good morning, Mr. Box.
Good afternoon.
You and I have talked a couple of times on the phone, and this morning was the first time, no, I take that back. About a year ago or so, maybe earlier this year, we met when you were still in the U.S. Attorney's Office here in St. Louis, right?
Yes, that's correct.
Are you still in the U.S. Attorney's Office?
No, Judge, I moved to private practice.
Oh, okay. Here in town?
No, I moved to Dallas.
I want you to tell us a little bit, the people here in the courtroom, particularly Judge Mason, a little bit about your background. Because when I heard it, I said, I don't think I've ever had a witness with a resume like that.
Objection, is there a question?
Yes, there is. How old are you?
That was all right. Didn't ask it that way. Just go from college, law school, first, second, and third job. Just
Hometown
let
state.
go.
It's okay.
College, I went to Morehouse College in Atlanta. Afterwards, I have a degree in accounting, and afterwards I earned a CPA.
After that, earned a JD from St. Louis University School of Law. After that, I earned a master's in public administration from Harvard Kennedy School. After that, I earned a LLM in tax law from Washington University School of Law.
That's your education.
Yes, ma'am.
How about your work history?
I started out after college in the Army. I was a tank commander. Then I went to the FBI for 9 years. I worked for a CPA firm for a short time. Then I went to the FBI as a special agent for 9 years. And then I left there and worked for a large CPA firm for 3 years. And then I left there and went to Congress. And then I went to war in Iraq. Then I came back and worked for the Department of Defense. And then I came here and worked for the circuit attorney. Then I went to the U.S. Attorney's Office, and now I'm in private practice.
How long were you with, you mean the 22nd Judicial Circuit?
Yes, I worked for the.
So how long were you here?
18 months, almost 18 months.
So you went to St. Louis U Law School, went to Washington U, got a master's here in St. Louis, worked here in St. Louis as an FBI agent for 9 years, worked in the circuit attorney's office here for a year and a half or so, moved over to the U.S. Attorney's Office, and then you're in a private firm called Reed in
Yes.
Dallas.
Yes. I don't even know if I mentioned the U.S. Attorney's Office, but I did. After I left here, yes, I went to the U.S. Attorney's Office.
Are you married, sir?
I am. Been married 27 years, 3 adult sons.
3 daughters?
3 adult sons.
3 adult children?
Yes.
Okay.
Sons. It ain't hard.
So,
All of them out of your pocket?
Well, I have 2 in college who are mostly out of my pocket.
Yeah, I can feel you on that.
I've never heard that term before.
so
To ask my kids that.
you interrupted a conference you're in to come here to testify, right?
I did.
When did you join the Circuit Attorney's Office here in St. Louis?
March 2018.
And what did you do?
Hold on for just a second.
What were you hired to do?
Counsel, hold on for just a
Okay, I'm
second.
sorry.
Judge is like, here's my name and phone number. Let's go out for drinks after this. Shall we talk about our kids being out of our pockets?
Go ahead.
Celebrate.
What were you hired to do?
I was initially hired as the chief investigator
And what was your job as a chief investigator?
to oversee the team of investigators and their various duties throughout the office in the 22nd Judicial District.
At some point in time, did you get involved in the Lamar Johnson case?
I did when I was working with the Conviction Integrity Unit. I actually took over the Conviction Integrity Unit after Robert Steele left.
You took over.
Hold on, I'm sorry. Were you an ACA or a?
Eventually, actually, when I came on as the chief investigator, I also assumed the role of an ACA, but I didn't prosecute cases. Got to the very end.
I was wondering why I hadn't mentioned. Go ahead, continue, Counselor.
So you did get involved in the Lamar Johnson case.
I did.
What was your role there?
Well, I shepherded the case once Robert Steele left.
Did you eventually become the lead of the Conviction Integrity Unit
I did.
while you were looking at the Lamar Johnson case?
I did.
Tell us what you did in connection with looking at the Lamar Johnson case.
I started out by reading the entire file. Quite frankly, I read every scrap of paper I could find on it, the prosecutor's file, there was also information that was put out by the Midwest Innocence Project, so I read that as well. And so I just consumed every piece of information I could find about the case.
Did you interview any witnesses?
Yes, I interviewed Lamar Johnson.
He's the only one you interviewed?
Yes, well, I also went to a deposition of Elking, Mr. Elking.
When you say went to, that means you observed the deposition, or you actually executed it?
I attended it, no. Lamar's lawyer executed it.
All right.
Lawyer executed the deposition.
So you never had any conversations with Mr. Elking yourself?
I did not.
All right. Did you ever observe any conversations between Mr. Elking and someone from your office other than a deposition question and answer?
No, Your Honor.
Go ahead.
Okay. So after this, did you learn whether or not any payments had been made to Mr. Elking to testify.
I did.
Tell us how you discovered that.
Well, there was information floating about, and information from the file I read and other information from the Midwest Innocence Project that seemed to indicate that there may have been payments made to Mr. Elking. So I went to the victim witness coordinator, who was, at the time, her name was Sarah Phillips. Her name is Sarah Phillips. At the time, she was the victim witness coordinator. And I explained the situation to her and told her that, asked her if she could find any information related to payments to Mr. Elkins.
And did she find any information?
She did. She came back within a matter of days and brought me a folder. It was a colored folder, and it was full of information about payments made to Mr. Elkins.
You don't by any chance recall the date of any of those payments, do you?
No, Your Honor.
Do you have that folder by any chance, or photocopies from the folder he's just talking about?
What I have, it doesn't have a date on it, but I think it was roughly January or February of 2019.
January to February of 2019?
Are you asking about the discovery of the documents, Your Honor?
No, I'm talking about when these payments were made.
Oh, no, oh, I'm sorry, Your Honor, I misunderstood. The payment started on November the 4th.
Do you know if that's true or
and
not?
went into 1995.
Do you know if that's true, November the 4th?
That's what the documentation that was given to me indicates.
All right, and then what was the end date, sir?
The last, in this summary, I got a date of March 16, 95.
3/16/95.
But what we don't know, Your Honor, is whether that was the last date, because
Well, what we don't know, we don't know. I'm just coming on what I do know.
that's on the summary that I have that he's going to identify hopefully shortly. His last payment shows March 16, 95.
Okay, then
Okay, so these payments that he's talking about are what we heard in the Lamar Johnson's side's opening about Mr. Elkins, who we just saw on the stand. He's the eyewitness. He's the one that, has said now he doesn't know who it was. They paid him. I don't know the amount. It's been $250, but it doesn't take from November to March. That's a long time to pay $250 to somebody, but maybe. So the state did not turn that over to the defense in the original trial, that they had made these payments to Mr. Elking and offered him, protection and that sort of thing, which I assume he's going to get into more too. We'll go until we can't with this guy.
that's fine. I want you to go through that foundation. Don't misunderstand me. Silly question, which I should know the answer to, but I don't. What was the date of Mr. Johnson's trial?
July 11 and 12,
1/11/12/95.
1995. 1995. Remember
I'm
this,
sorry, you said July, did you not?
July 11 and 12, 2000.
So then these payments were all executed before the trial.
Before he got, absolutely right. Yeah. That's what Elking testified to. Once,
All right, stop right there, and I have one quick question for
Sure.
Mr. Box. Were the existence of these payments brought to the attention of defense counsel before trial? If you know.
Defense counsel, Lamar's, which counsel?
Lamar Johnson's attorneys.
Yes, Your Honor, by me.
No. You came in after the trial, didn't you?
Oh, during the trial, the actual trial. And
In other words, were they brought
No.
to the attention of his defense attorney, Mr. David Bruins, I think was his lead counsel, before July the 11th of 1995?
not that I'm aware. Everything I've read indicates that they were not.
All right. You got to contradict that if you can.
Thank you, Judge, and just for the record, we would object to foundation and hearsay.
Well, he looked over the file. He just testified to me based on his personal recollection. So at this stage, the objection is overruled, but we'll see how it goes. Go ahead.
we will have two witnesses, Your Honor, that say,
You don't have to give me prediction on your witnesses. I just asked this person. He gave me his answer. You may continue.
So, Mr. Fox, the information that you received, I'm going to hand you Exhibit 16. That is in your book, I believe.
Yes, it is. All right. It might be easier if we have a working copy like this. Thank you.
Can you identify that, Mr. Fox?
Yes, this is the information from the folder I received from the victim witness coordinator.
And
Do you know
that-
why this is labeled sunshine request? That the newspaper asked for it as well?
No, Your Honor, the defendant did, Lamar Johnson. He filed a sunshine request.
All right. Keep talking, Counselor. I was just
I'm
curious.
going to send you, and show you next week and mark for Exhibit 123. All right, that's in your book also. This is a letter dated April 26, 2012. From Michael U. Assistant Circuit Attorney. You seen that, sir?
Yes, I have.
Would you read that to the court, please? I don't have a copy in my hand.
Objection, Judge, like the foundation is hearsay, she's having a repeat visit.
And your objection if the exhibit speaks for itself?
Yes, Judge,
Is there any objection to the exhibit as evidence?
yes, Judge, again, foundation, there's.
He does not recognize this exhibit himself?
So you recognize it, Your Honor.
I do recognize it.
Your foundation goes to,
Judge, my foundation goes to, he didn't work there, he's not an author, of the letter, he didn't receive the letter,
but how could he recognize this if it didn't come up during the course of his actual work?
and Judge, that may be the case, but it's still, no foundation for this specific.
If it came up during the course of his actual work, what does that make it? A public record.
Judge, also, I don't believe there's been any testimony, at this time regarding, was this document kept in the regular course of business, where was it located?
Well, you're right. I didn't get the specificity of that. I kind of put that together, giving the totality of what he has said up until this moment. If you want to ask the trigger question and you can get the right answer, you go right ahead. I'll sustain the objection till the trigger question is asked. Go ahead.
Did you learn that Midwest Innocence Project, others have been requesting information with respect to whether Mr. Elking had been paid for his testimony?
I did. There was requests were made for many years.
Pardon?
I did find out those requests were made for many years.
Requests have been made, and did you find out whether, in fact, they were answered by saying, we don't have any information?
Objection, leading.
If he knows what the answer was that was given, just ask him, do you know what response was given? The official response.
Sure. Do you know what response was given, Mr. Fox?
Yes, we are unable, generally, it was almost invariably, it was, we are unable to locate any records. In other words, we do not have any records related to payments.
And are you looking, excuse me, I'm sorry. That letter that you're looking at, is that a letter generated by the office of the Circuit Attorney for 22nd Judicial Circuit?
It is, Your Honor.
Is it a letter that is normally kept in the course and conduct of the business of the Circuit Attorney's office?
It is, Your Honor.
Those are the trigger questions. That's all I was looking for. That's all the Assistant Attorney General was looking for. You may proceed.
Thank you, Your Honor. You did a good job for me. Appreciate it.
Oh, no, you don't.
I do. The exhibit 16 that you have, Mr. Bond, there's handwritten summaries. Do you know who wrote those handwritten summaries?
I do not know who wrote them.
But they were nevertheless, that was the documents that you found in the files in the Circuit Attorney's office that Mrs. Sarah Phillips gave to you, right?
That is correct.
Mrs. Sarah Phillips was a person that at that time was overseeing the witness protection unit.
Yes, she was the victim witness coordinator.
In addition to the payments, and that summary shows over $4,000, I don't know whether there's other payments or not. Were you familiar with how the witness protection unit works in the Circuit Attorney's office?
Not in great detail, but generally.
Do you know where the money comes from?
Oftentimes it comes from the state.
Could also come from the St. Louis Police Department.
It can.
In addition to finding payments that were being paid to Mr. Elking, did you learn whether or not his parking tickets were being taken care of?
Yes, there was also paper or receipts indicating that his parking was paid for as well.
Which could add up to more than $250. Those can get quite expensive, from what I heard. Never had.
Did you learn whether or not those parking tickets
I got a question for you. You said parking tickets paid. Now, were they paid or were the charges waived and the tickets dismissed? Or do you know? I wasn't asking you, I was asking
Yes, Your Honor.
Mr. Weiss? Okay, I'll wait till you look up. I was wondering.
No.
So, Stormy, what they're talking about, they're still talking about Mr. Elking, which is who we just saw on the stand when we started and who we watched Friday. The state paid him. So now they're talking about, did the state also pay his parking tickets as well? Or did the state just waive his parking tickets? To me, it doesn't matter. He still benefited the same way if he didn't have to pay his parking tickets. So I believe they're trying to find the parking tickets. Just to show that more of what the state gave Mr. Elking for his testimony. So that's what this guy that is on the stand now, he came in 2018, 2019, and he reviewed this case. And then he's the one that saw that there was payments made to Mr. Elkins. He's the one that saw whatever else he's going to testify to, but everything that is wrong with this case and why they asked for a new trial, and why we're here now.
You're mentioning parking tickets. Were the parking tickets paid from the Crime Victims Compensation Fund, or were they waived by the? So the city councilor was asked to nolly prosecute, because that's the party that would have engaged in such an act.
Yes.
And then they nollied all the tickets. I'm presuming.
Yes.
You tell me if I'm wrong. On behalf of the circuit attorney's office.
You heard Mr. Elking say that he's been stopped between the time he was in a witness protection program at the trial, and he told them they were going to take him to jail because they had a lot of outstanding tickets, because he's going to lose his license. And he said, "Look, you've got to call Joe Nickerson. I'm a star witness in this case. I don't want to go to jail with the people that have been arrested that were involved in killing." And they took care of his tickets. And I'm going to show Mr. Box Exhibit 19. And you guys, it's number 19. And you can look it up.
I agree, George. I do think he's open to all the evidence and testimony. He does seem fair, but I do think he's tilted slightly
Find
towards
that in
the
the file?
defense.
Yes, I found this in the prosecutor's file, which
At
was
this point.
separate from these documents. They were not with these. This was separate.
Actually, yes, Your Honor, I got a color copy.
And just for the record, what you were being handed contains more information than what is on exhibit 19. If you would like that marked as an exhibit, the state would have no objection to.
You just want to admit it separately.
Well, I just want it clear for the record that what the court was handed, is a little more detailed, than exhibit 19. It's not exact colored copy.
Well, go ahead and tell me what you mean.
So.
What way is it materially different?
Well, exhibit 19, Judge, appears.
Oh,
you can't see the
I
copy.
see.
And what they handed to you is colored and clear for the court, but also has a back.
All right. Well, the only thing that's relevant is what's written down here, I'm assuming. Is that correct? The only thing that's relevant is what's written here. Is anything relevant about the bottom? It looks like it was written on some of the old yellow paper we have over there. Is anything relevant about the bottom of this?
I don't think so, Your Honor. I just think this is not like it looked like it was a big paper.
All right. Well, okay, it's pink. Is there an
Well,
objection to the
haven't seen
pinking
their
of the paper?
who they're putting on yet.
All right.
But I do have an objection
Don't know.
regarding hearsay.
On the bottom part or the top part?
The entire thing, Judge.
All right, so the objection is hearsay, and your position is being hearsay, because didn't I hear you pulled this from his investigatory records, or did I hear wrong?
These documents were in the circuit attorney's file. Mr. Box has testified, yes,
Right.
that was something he discovered.
Doesn't that get him into the public records exception? Tell me what I'm missing.
Judge, again, I don't recall that foundation being laid.
Well, I mean, you're right. It wasn't laid with specificity. You are correct in that regard. With public records, you got to go ahead and get out. By the way, was that record something that was kept by the Secretary's office in the normal course and conduct of its business? I see what you're getting at. You want me to dot the I's and cross all the T's, so I will sustain the objection, give Mr. Weiss leave to develop this foundation. Although I am staring at it, so. Problem with a bench trial case.
Mr. Box, do you also remember
Hello, Bree.
when you looked in the file on the margin?
It was Bree's birthday yesterday. She turned 29 for the 4th time. But hello, Bree. I'm glad your 36-week checkup went well. Time is coming. Gonna be here soon. I'm excited. Yes. She had her 36-week checkup today, and everything is looking good. She's a little lower. Head down, getting ready to make her entrance. And I saw Bree. I saw Bree on Saturday, and that was the first time that she has ever said to me, "This, I'm done being pregnant." That's how I know she's getting close. Because the end is miserable.
Let me ask you this, and I think I forgot to ask you. These payments history that you looked at, that you discovered, were they in the Lamar Johnson file that you initially looked at?
They were not.
But they were brought separately from the witness protection unit to you, right?
Yes, after I specifically inquired about payments related to this case.
So if someone was looking in the Lamar Johnson file, they would see no record of payments.
No, not at all.
Now, you understand the witness protection office is under the umbrella of the circuit attorney, as I understand how that office works.
I am not educated on that, Your Honor. I believe that the circuit attorney's office has something to do with it. They have full-time employees like Mr. Fisher Phillips.
Am I correct or incorrect on that? Is it under the umbrella of the 22nd Circuit Attorney, or is it completely independent from the circuit attorney?
It's under the umbrella of the circuit attorney's office.
And then, that being the case, then it's a record of the circuit attorney's office. If this person says he got it from an official record of the circuit attorney's office. And I'm having a little trouble with taking care of the hair splitting that I sense in your objection. I'm not sure how there's any real reasonable possibility that the Public Records Foundation cannot be laid if it hasn't already. So I'm going to overrule the hearsay objection on those regards. relevance is pretty clear, so there's no relevance issue. And obviously no undue prejudice because this goes directly to issues before the court. So this exhibit submitted, proceed.
Did you also learn about letters written between Mr. Dwight Warren, who was the prosecutor in the case, and William Mock, who was the jailhouse informant?
I did.
And they
Can
were,
I see that white piece of paper right there?
Absolutely, Your Honor.
Just hold it up for a second. It's exhibit 19. Thank you.
You're welcome, Your Honor.
I'm sorry, I just need to make sure I wrote down the correct exhibit number on this pink slip. All right, go ahead.
okay, Your Honor?
I'm fine, please proceed.
I'm going to hand you next what is then marked for identification. It's 99. This is a letter.
Judge, it's hard enough to hear.
Board of Probation and Parole, dated June 26, 1995.
What's that exhibit number again? Did you say
It's
99?
99, Your Honor.
Yeah, I'm just going to it.
And Judge, may I see?
It was 99. I seem to be stopping at 97.
There's probably another version of this, Your Honor, maybe have another number.
You can have this one. I'm quite familiar with it.
I don't need it. Family Feud.
Let me see if we have it, the number of it. Your Honor.
Getting ready to lose this box.
We have
Which
it.
sucks.
No. No, I've got that. Judge said it's not in his book.
Yeah, at the top, if you look, it's 97, then it jumps up to 114. If you don't mind, I'd appreciate it.
Is that 114 number? No, not yet. I have 99, yeah.
114 is well, it's something you hadn't gotten to yet.
Okay.
That doesn't have anything to do with, it looks like a duplicate of 19, but there's more stuff written on it. So I'm not going to worry about 114 unless
You have a copy of 99, yeah.
Yeah, I do now. Yes.
I don't believe I am.
Okay. Box, I'm handing you what has been marked for identification.
Survey
I have a
says.
copy.
All right, that is not me. That is them. For 1 hour. Don't worry, we're not going to sit and watch it. Unfortunately, because whatever happened, we don't get to hear Mr. Box's testimony, which sucks because it was probably really interesting. The state's doing their job. They don't want any of this stuff in because it makes them look bad. So he just, that spinning circle, just don't worry. It's just him. It's just him. I thought maybe we would at least have the audio, and they were like, no, you don't need it. It's like, but I do. I really wanted to hear what he was saying. And then we get a new witness. This, I believe, is the prosecutor. There's no audio. So I'm going to go to where the audio is so that we can hear him. Also, not me. That is, this is them moving and trying to get their feed and everything going. And I swear they go over and hit the mute button. We'll hear him in just 1 second. Give us sound. You guys are making me glad I'm not having any kids. Good heavens. My gosh. I didn't know some of them came out ready to graduate high school.
In most of these cases,
There
I
it
don't know
is.
whether I'm going to have to go through this with you or not, maybe I don't, but in most of these cases, defense verdict, particularly the public defender's office, sends an office to the prosecutor requesting certain discovery, right?
Yes?
One of the things they would be requesting is any information that you've dealt with the witness, influenced the witness in any way.
Repeat your question about?
You remember getting any kind of request where you would have to disclose anything that you did to influence a witness's testimony?
This is your
It's broadly
said that like
phrased, but I received from him the essence of Rule 2503, request, and I gave it to him.
You gave him the information that you had at the time.
Yes, sir.
This is Exhibit 73, it's in your book, Your Honor. You recognize it. That's a request for discovery from David Brown.
Yes, sir, that would appear to be the prototype of every request from the public defender, or basically from any defense attorney.
And your next one has been marked for identification as Exhibit 76. Also in your book, Your Honor, this is a letter from you, Mr. Brown, dated December 21, 1984. And look like you're disclosing some items of discovery, right?
Yes, sir.
But basically what you gave him is 2 police reports.
Yes, sir.
Nothing about relocating Mr. Elking or any payments to Mr. Elking, right?
That is correct.
Okay, sir.
happy. It's a pain
I want
you
to talk a little bit about Mr. Bach.
Mr. Who?
Mr. William Mock.
Mock, okay.
William Mock. William Mock was the jailhouse informant that came forward, correct?
Correct.
And you were not aware that he had already come forward in 1992 in a case similar to the type of testimony he gave where he heard somebody in jail confess to homicide, right? You were not aware of that.
Well, I don't know how similar it was, but yes, I was unaware of any sort of arrangement of testimony for special consideration anywhere else.
And I think you indicated at trial, when you were arguing to the jury, that he really never asked for anything other than a letter to the parole board, right?
I remember something like that in the trial, but I'm not sure exactly how you phrased that question. But I said something like that. He'd never asked for anything other than the letter to the Board of Parole, which I provided to David, and which I wrote to the Board of Parole, and that's all I did.
He started writing letters to you, and you responded to some of them, right?
I don't know that.
You remember him writing letters to you and thought that, where he's telling you he thought his testimony ought to merit a pardon from Governor Carnahan?
I'm not sure what you're just asking.
Do you remember receiving a letter from him where he said he thought his testimony should warrant a pardon from Governor Carnahan at the time.
Well, no, I don't remember receiving any letter, and my response would have been, no.
Or that he wrote you a letter and saying he thought that he ought not to be put back in the Department of Corrections, that he ought to be on probation or parole, and asked you if you would recommend that.
I don't remember that, but I never would have recommended probation and parole. And I never wrote any letter to Governor Carnahan. Carnahan, did you say?
I don't remember who
Hold
the
on for a second. I'm giving you what's been minute as exhibit 114. You have it there with you already?
Yeah, 114A, this?
Correct. You see the bottom
Yes, sir.
pink square there?
Yes, sir?
Is that your handwriting in there?
No,
or
sir.
not?
No, sir.
It's not your handwriting, okay. You know what anybody would write down that they were talking to Cranston Mitchell,
Oh, is that-
chairman of the Board of Probation and Parole, with a note that he'll be sent
That,
to Ozark Correctional Center for 18 months?
I would
You know why
imagine.
anybody would write that
Oh, sorry,
down?
I thought you were finished.
Go ahead.
I would imagine that might have been a note, not from me, but by Vicky Myers, saying maybe it should be addressed to Cranston Mitchell. But I know that I
Well, why
addressed
would you have a handwritten note that Vicki Myers would have written, no doubt sitting at her desk in her office in Jefferson City?
I have no idea. You might ask Vicky Myers why it got into my file, but I have no idea. All I can say is that the top part is on what appears to be one of our folders, and it has Judge Mason, not you, a
I
different
know,
judge,
Donald.
Jackson County, Division 11. That's and Vicky Myers, that's my handwriting.
Okay.
Oops,
I had to
crossed.
know where to send the letter,
Mhm.
and I ended up sending it to Vicky Myers.
This is a letter, Mr. Warren, where it says, "Dear Mr. White, RMT," and it is from William Philip Mott, dated June 1, 1995. That's 160. That's before the trial, right?
It would appear 6/1/95 is the date of this.
Hold for just a moment. Did you not, in laying the foundation for 114, did you tell me that this handwritten portion was on the back side? This is the front and back of the same piece
I
of
think
paper?
so, Your Honor.
How did you arrive at the conclusion this is the front and back of the same piece of paper? Is that how you photocopied it? Somebody, I heard that being spoken.
That's part of our objections from earlier, is we don't know anything about where this stuff is from. So we can't answer those questions.
No, Your Honor. It was a mistake. When the Attorney General's office came in, that slip was among the circuit attorney's records that was available for them to photocopy. And I don't know specifically about how that was photocopied like that, but I can say that that's in the records.
That's correct, Your Honor. I agree with Mr. Puff. Whenever we reviewed the file in the circuit attorney's office, that piece of paper was there, and Mr. Puff and I both requested that a front and back copy be made, so
So this is the front and back of the same piece of paper.
that is my recollection.
Let's return to exhibit 114, Mr. Warren.
Oh, 114, okay, 114A.
Now, you've already told us that some of your handwriting appears on, I will call it the front side, the top part of this piece of paper. And all of this information concerning Cranston Mitchell appears on the back side of that exact same piece of paper. You have an explanation for me?
No, sir.
All right. Go ahead.
I think the judge could have just done
Hold
this.
on, I think you wanted me to review 160, I'm still reviewing it.
So the prosecutor, he's in a tough spot
So
because
he apparently is You remember getting this letter?
He either is going to have to admit he did something wrong, didn't know something, didn't have something, lied about something, and he's not going to want to do that. He's there, so we'll give him credit. But he's there for a reason, and you know, I don't know. I think they could have handed all the evidence to the judge and he just asked questions himself. But we've all heard the judge say, "I'm not, you do the work for me."
Um, Not really, but I could have.
He says, per our conversation today with yourself and John, I felt the need to put my intentions in writing. Who would John be?
I don't know unless it was my investigator, John Moss, the same person to whom I gave his pedigree to run his record. That's the only possible John that I can think of.
He goes on to say, I will testify articulately, accurately, and honestly to the information I acquired while at the city holdover, bringing about a successful resolution of this trial. I don't believe that anyone in the legal system will disagree with the value of my testimony in this trial as opposed to this conviction I am now serving. I'm willing to testify so long as I don't have to return to the Department of Corrections once I testify. I won't live in protective custody or any institution once I testify. Do you remember talking to him about that?
No, sir. This is Mr. Mock talking. It's not me. It's not my response to him. I would not concur with what he was suggesting.
Okay. He says, I'm serving a 5-year sentence for CCW, or CCLU, I can't read it, which I now have been serving since early '93. I feel my testimony is worth a pardon by Mr. Carnahan or a reduction in my sentence by Judge Mason, Division 11 of the Jackson County Court, Kansas City, Missouri. Cranston Mitchell, the head of probation and parole, can only parole me. And he and his agents can also violate my parole and return me straight back here for next to nothing. I can't take that chance. These young blacks.
What was that last part? Where are you?
I'm reading at the bottom of the page.
Okay.
Are too tight knit in this prison system. Of course, I don't plan to violate my parole, but it's easy to wind up right back here for next to nothing. If that were the case, the blacks would know I testified before I was returned to prison. That will not happen. I propose this, that Judge Mason reduce my 5-year sentence to time served with something I can't read of for my testimony, or that Governor Carnahan pardon me with time served, thus guaranteeing my safety away from the Department of Corrections. Thus, if I return to the MDC it will be my own.
You need more water? I do need some more water.
Yeah. Can somebody get him some water?
So what they're talking about right now is a prison snitch's letter he wrote to the prosecutor. Mr. Mark is his name. I don't know what he buddy.
Ah, bless you. Thank you.
That was nice of her.
You recall having conversations with him where you told him, I cannot get you a pardon from Judge Carnahan. I cannot guarantee you won't go back to the Department of Corrections.
If I had a telephone conversation, number one, it would have had to have been initiated by Mr. Mock. I had no way of phoning wherever he was confined and talking to him. That's number one. Number two, this is his desire. I'm not going to do it, period. If I buy testimony, I've got to reveal it to the defense, and that just torpedoes, weakens my case. So I'm not going to buy his testimony, no matter whether he thinks it's earned or not. He can dream on.
I gather you don't recall turning these letters over to Mr. Bruns prior to trial.
I don't, and I don't know that I would have. Who said that?
Well, I'm hoping nobody was commenting on the witness over there. So I'll just let it go. Go ahead.
Who said that?
You okay with coming back in the morning? if
One of you.
necessary? It's kind of going to be
Okay, but
necessary.
not looking forward to
10
it.
o'clock.
You got it.
I'm sorry, continue, Counsel.
Oh, okay. Do you remember after trial, after the conviction? Let's set this up. So there was a 2-day trial, right? About?
I suppose, at least.
Okay.
You know, a day for word hour at least. And then I'm known for my brevity, I probably would have put the case on in 1 day.
So Mr. Bruns filed a motion for new trial within the time required by the rule, right?
I would assume so.
Do you recall in that motion learning about the fact that Phil Campbell, the other person arrested, had written letters to Lamar Johnson while Lamar was in trial? Remember that?
I remember at some point, I was told that Philip Campbell had written a letter to Lamar, and I notified the police department. They secured a search warrant and I think seized letters from, I think they were in Lamar's possession.
This exhibit is part of one of the police records. There's a thick one that you hold on to 610. That number just 44. And this is a supplemental incident report of Lamar Johnson. And I'd like a couple pages. Page 1, primarily.
I don't see the 44A.
I don't think it's in your book. You know, it's part of a large packet of police reports.
Oh, I just need to get what you're discussing with this witness. It's all you have to give me.
So this is on page 3. I just want to give you this, make sure. Attorney, on Thursday, September 14, 1995, homicide detective Thomas Beretta, DSM 16.
Your Honor, I'm just texting you, he's reading off the report, you can probably read the report I have.
Do you, in a case like this, right? I mean, if you want to challenge, like it's a fake document, Your Honor, it has nothing to do with the cases, or unduly prejudicial, that kind of thing, that's fine. I understand the objective. We're in front of a jury. I might pay a little more attention to it. But I can pretty much parse these matters myself. Is this some sort of fake document that you think it's untrue, that I shouldn't even consider it? All right, then go ahead, counsel.
Mr. Warren?
You can call me twice.
Deputy Plum. Page 1.
And your question is what?
Is that refresh your recollection, if you need to, that there was an incident shortly after trial, I mean within a few days after trial, a motion for new trial is filed. You learn about that, and there's mention in that new trial motion about letters to Lamar in which Phil Campbell is basically admitting he was involved in the murder. Phil Campbell still has to be tried, remember? And you were assigning his case, right?
Yes, I'm still not puzzled as where you're going.
So I asked, did you instruct the police department, did you get a search warrant? Did you institute getting a search warrant for the police to go over and search Lamar Johnson's cell?
Maybe I was reading this and tuned out. Did I initiate the police getting a search warrant? Yeah, I told them that they had to get a search warrant for the letters. If that's what you're asking, the answer is yes. In fact, photographs were taken of the search of that case, of his cell, right? Well, they may have. I don't know. I don't know that I ever saw him. Okay. Remember, this is after the trial. This is shortly after the trial. Yes. Yeah. Well, I don't know that I ever saw him. I'm going to show you Exhibit 55.
It's the fun of attorneys and examining attorneys.
Going back 30 years ago, but that looks like Tom Toretta.
Tom Toretta? He was in the police department?
Yes, you can date it because of the beeper on it.
Yeah.
You recall asking if pictures be taken?
Do I recall seeing this picture?
Yeah.
No, I don't recall it. I'm not saying I didn't, but I don't recall seeing it.
Okay, there were a number of pictures taken, actually.
Well, same response on all of them.
Never received a copy of that. It looks like Lamar Johnson.
What is this yellow and black thing?
I don't know.
Is that a shiv?
Oh, the yellow thing, that's just a fold up, piece of,
That's a piece of paper.
envelope. Yeah, that's just an envelope.
Oh, well, no wonder.
Only question I have is how would he know if this was Lamar Jackson's cell?
Because he issued the go over and search.
You're walking away. I can't hear you, sir.
Because they went over and asked that he still be searched.
I asked what?
That he still be searched.
Hold on, let me shortcut this. Do you see Exhibit 57?
Yes, sir, I do.
Was
I had
this-
it upside down.
Was this sent back to you by the Department of Corrections with a notation that this was the cell of Lamar Johnson?
I think
He's
he's,
in the city jail at this time. Right?
Was this sent back to you by the city jail
no,
with any statement that this was the cell of Lamar Johnson?
was what?
That this was the cell of Lamar Johnson?
No, sir.
You have any idea whose cell this is?
I would suspect it's Lamar Johnson because that was who I was told wrote the letter, and that's who I suggested that they get a search warrant for the letters in Lamar Johnson's cell. So I assume that that's his cell.
Well, let's operate then on the assumptions that it's the right cell. But when you talk about foundation photographs, somebody has to say, oh yeah, that's it, and fair and accurate copy, and I know what it looks like, and that's it. And you don't have that. So go with what you got, but I'll only take it for the weight that I can give it under these
I
circumstances.
appreciate that, Your Honor. Actually, it's leading up to the next series of questions. Did they bring back to you the letters that they found in Lamar's cell that Phil Campbell had written to Lamar?
I have a vague recollection of having seen that, but I cannot swear.
Let's look at them. I'm going to send you Exhibit 2.
Okay. Like I said, it vaguely sounds familiar.
So can you tell us now, sitting here, that these are copies of the letters that you received from the search that you had directed at Lamar Johnson's cell?
No, I can't say for sure, but I wouldn't say I didn't.
You remember, sir, at the hearing on the motion for the trial, you were there?
No, I don't know, was I? When was the date?
You remember that?
When was the date?
These are part of the record before you. Mr. Brown says, just for the record, I take it we are stipulating that these letters were written by Phil Campbell. Mr. Brown, for the purpose of this hearing, I would be more happy if Phil Campbell wanted to stipulate that they are in fact his letters. For the purpose of this sentence, I'm willing to agree that they are written by Phil Campbell. So, I'm showing you on the chart, one of these exhibits, and it's signed by Phil. Do you know who Phil is?
I assume that you want me to say that that's Philip Campbell, and I suppose it is, but I don't know that.
Says, what's up, dude? That's effed up. You got convicted when you didn't do a thing. Told my lawyer to let me tell the truth, but he won't, because he said I could get my,
I could beat my case.
I could beat my case. I'm sorry, I got you in this, but me and didn't try and kill Marcus. It just happened. That white boy ran when I pulled him from the steps. I didn't see him anymore after we shot Marcus. Those people told him to lie on you. Keep your faith in God, because he will make everything all right. I told you to get a lawyer because the PD be working for them. I hope you get approved. Stay up. I don't know what that means.
That says, I hope you get appeal.
Appeal.
Okay.
You get appeal. I know it's.
Thank you, Your Honor.
Yeah.
I'm not quite there yet on that.
That's okay. I just have a question. Do you have any idea as to when that note was written?
Those were written between his conviction, and I think when that search warrant, it's in this report.
Somewhere between Johnson's conviction and when the search warrant was executed.
And that was, I think, the search warrant might have been September. It's in that report.
Your Honor, I would just say for the court that whenever the record for the motion for new trial and on appeal, they didn't consider the letters because they couldn't find any date, and because they couldn't be authenticated by a date, that's why they weren't considered on.
Yeah, but I have a little bit more. You may not know what I have in front of me, but I see a file stamp date here. Although this is kind of down the line though, because I have September the 28th, 1998 on my file stamp here.
So that's why they were introduced in another proceeding subsequently, Your Honor.
Yeah, they were introducing something because they were file stamped.
Well, I think this might clear it up, Your Honor. It says,
Hold it out. The file stamp ink is a little better here. It says September 29th, 1995. So that actually is what the file stamp date is. And
and this police report says, Attorney Warren provided on August 4th, 1995, Lamar Johnson, his attorney, David Brown, filed a motion for new trial. And then they went over it and they said,
these are most likely attachments to the motion then, to have that file date
well,
on them.
not only attached to the motion, but they were seized by September 14th, 1995. So it was fairly shortly after the conviction. They were both in jail.
That would be a logical conclusion.
They were both in jail together at that time.
Mm-hmm.
I really want to grab that attorney by the shoulders, move him to the mic.
I believe on the direct appeal, which the record is stipulated to being accurate for the court's consideration. I believe on direct appeal there was some sort of evidence that it's possible, and the court of appeals could not ascertain that those letters had been received by Mr. Johnson prior to the trial date, because that could not be clarified. That is why they went.
I wasn't concerned about prior to the trial date.
Okay, I just want to make sure the record is clear on it.
Right. In fact, I was concerned as to how soon after the trial date these were likely to have been written. And I have my answer.
when you got these letters, did you read them?
If I got them, I would have read them, yes.
Did you use them in connection with the motion for new trial?
I don't believe I would have.
Do you remember that?
And again, the record of that proceeding will speak for itself.
Do you remember that? Let's look at this, another one of these letters. Lamar, I don't know why you keep telling people that we tried to kill Marcus. Went up there to pistol whip Marcus about talking shit to public. When we ran down out the gangway, DA tried to grab Marcus. They started wrestling with a gun, and that's why we had to shoot him. Don't know that monkey foot
Lied.
having on mask. One of the reasons why DA put one on is because Marcus knew he stayed down the street, and he might tell what we would have did to him. Nobody did point no gun at that monkey after we shot Marcus. When I turned back around, he was gone. So we ran back to VA house. I know you was your homie, but you know how the game goes. What Marcus had took. But DA, I can't read the DA something, and shot us. Do you dig what I'm saying? Just be cool and stop.
That's the last degree, even if the VA gone and shot it, is what it says.
Thank you, Honor. Just be cool and stop telling people bullshit. All right? Let's go and stay. Now, those letters were introduced at the hearing on the motion for new trial, right?
I don't know if they were, okay. When was the motion for new trial? I asked that again.
And the motion for new, they were introduced at the motion for new trial.
When was that? Is my question.
Well,
because I was on active duty starting sometime in December.
I think you were there.
That's what I'm trying to figure out.
Yeah, I think that was before you went on active duty, which was what, after the first of the year?
If that's so, then that's fine. I just
Hold
don't
on for
know.
just a moment. Yourself approach me, please.
I thought this prosecutor was on the new trial, but he wasn't going. So who asked for the new trial? Sorry, the audio on that is awful. And I really, really, really want that attorney just to stand by the microphone. It's not hard. I'm sitting in front of one now. I'm not walking around. My hair's falling in my face, but it's okay. Oh, it's okay because it was super confusing. I thought his testimony would actually be a lot better. So disappointed. We don't have much left of him. Also, I don't know if you guys have noticed or not. It started with the first day when I'm trying to make my cursor do things on the wrong screen. When they both handed up their binders with their evidence and stuff in there, and he didn't like the way that the state attorney, she's not a prosecutor, or maybe she is, I don't know, the long-haired younger one, he did not like the way that she handed hers in, and he's made several comments about it, and I don't think he likes her very well. Gosh dang it. It's kind of, I mean, it's very obvious that he doesn't like her. I don't know what she did to him. Also, still no closed captionings, which we need them more now than ever before. So we have not very long of this guy. At least for this day is broke up into 3 videos for some reason. The one with the Gerber face. I don't know who that is. The younger attorney on the set with the state. with the long hair. He has not liked her stuff so far. And that's who I'm talking about. I don't know who has the Gerber face. Yeah, he doesn't like her. Also, this court reporter here, I think I went past it. Um, but there's at one point when the camera comes back on, she is standing and she's looking at the camera and she's saying, "Hi, Mom." And the cameraman, you could tell he kind of responded. And she said, "My mom watches every day, and I told her I would tell her hi." Okay, good for you, court reporter. We all gotta have fun. All right, this just starts up. There is no wind up into it. So, still this prosecutor. I don't know. It's not even the same day, so I'm not sure what they were doing.
In another letter, you may have been gone at
It's
the
still this
time,
guy
but
who's
one
allergic
has
to
to
mics.
be this is dated 1/15/96, and I think that you indicated you were already over in Bosnia at the time, is that correct?
I was called up for Bosnia at least, I know sometime before December 15th. We flew out, December 25th. We flew out on December 25th. So it might have been a week or two before in preparation. But again, I would have been gone on the date of this letter, January 15th of 96.
The top of 169 suggests to me that Nels Moss is the one who looked over this letter. Is that the conclusion that you would draw from what's written at the top?
I would look at that and say somebody, and I'm guessing it was Ed Sweeney, would write to my, I assume of John Moss was my investigator, that note. What case is this? What was the deal for this guy?
And you don't recognize that as Nels? As in Nels
John
Moss?
is his brother, not Nels.
All right.
Nels had nothing, oh, I see something that says,
You
that could be
indicated,
Nels. You're right, John.
you indicated earlier that John might have been an investigator for you?
Yes, sir.
Okay.
And
Nels-
the judge is right. There is something that, it's a squiggle, but it looks like it could be Nels. And I have no idea how Nels, not that he was pushy, but he may have interjected himself.
Okay, now I might be remembering something incorrectly there, so I need to ask you. Because I thought you told me that in your absence, your cases would have been taken over by Nels Moss.
No, sir. By Ed Sweeney.
Ed Sweeney.
Yes, sir.
All right.
And I don't know how or when they gave him.
That's not me
I'm
doing that.
gone. I've got 30 files. Jennifer Joyce or Shirley Rogers would have
Assigned it over.
distributed it to, I don't know. I don't even know when Nels left the office, but he may have left the office and given it to Sweeney. I just know that Sweeney was the one that ended up handling the case at plea time, or trial time, which morphed into plea time.
All right, thank you.
Yes, sir.
So it looks like, and I'm reading this letter, Mr. Warren, that he does not know that you're no longer in the office because he in the last paragraph, he says, "Listen, Dwight, I have just one more favor to ask of you. It's just a phone call. It will help me get transferred quicker." So apparently he still thinks you're around, right?
I'm guessing so.
The last paragraph, in your involvement with him, however it was, whether it was discussions or letter writing or whatever, did you have any indication that he was a racist?
That he was a what?
A racist,
A racist?
yes.
I would be very surprised to find anybody in the Missouri Department of Corrections who is not a racist, white or black.
And I refer you to page 2 of this
Hold
letter.
on, repeat that again. Did you say that?
Yes, I think.
I figured that one was going to get the judge's attention. He was like, "Excuse me?" He said he would find it hard to find anybody in the Department of Corrections who was not a racist, white or black. I don't think he meant people that work there. I think he meant inmates, but we'll see. The judge's face, he wasn't happy with, he doesn't like it. He doesn't like that remark. I don't think I could have paused that one any better. I'll back it up just 10 seconds so you guys can hear it, and then we'll see what the judge has to say.
Missouri Department of Corrections, who is not a racist, white or black.
And I refer you to page 2 of this
Hold
letter.
on, repeat that again? Did you say not?
Yes, I think almost everybody in the Missouri Department of Corrections, not the staff, but the inmates,
Oh,
are racist.
oh, okay. I just
And I
want some
certainly wouldn't accuse
clarification.
your colleagues.
Just want some clarification. Thank
Yes,
you.
yes, thank you for clarifying that.
I'm referring you to the second paragraph
Second paragraph,
on page 2.
all right.
It's small, I've never been there, so people don't know me. Maybe I can hide out there long enough so I don't have to hurt someone or get hurt over this 2-bit N-word you guys breathe in St. Louis. Obviously, have you seen this letter?
No,
So you guys remember Mr. Mock, the prison snitch, was white. These are his letters, I believe, that he's thought he was writing to this guy who's not there. He's in Bosnia. Whatever we were doing in Bosnia at the time. Whatever.
I was gone. And I didn't see it in your stuff from 2019.
Again, diverging from this line. And I don't have any more questions on these letters.
You what?
I don't have any more questions of these letters. I have one question. I think we got it answered. But you don't recall ever sending any of these letters that we just looked at this morning to the defense prior to trial?
Correct.
Okay.
Because I didn't know about it.
I hand you 45, and this is a report from the police regarding the lineup.
Okay.
Is this something that you would have reviewed prior to trial?
Almost absolutely, yes. Yes, it's dated November. This would be part of the police report.
Right.
And it has a complaint number, the same one that was provided to the defense, the same one that you've referenced in the exhibits.
And you certainly were aware that, and did you review this lineup prior to trial? Do you remember, this report? Did
I thought you
review
were
this
still
report prior to trial?
Yes,
Okay.
certainly.
So you knew there were 2 lineups, one with Phil Campbell in, and one with Lamar Johnson.
Yes, sir. Those were the two.
And that Mr. Lamar Johnson did not pick out either Campbell or Lamar Johnson out of either lineup, right?
He did pick them out, but not at the time of lineup.
Okay.
Remember, he said, I could not identify anybody. He tells that to Nickerson at the time of the lineup. They go to the homicide office or somewhere, and he tells them, hey, I really could. It was, and he tells them 3 and 4. That's where he identifies the people in the lineup. But it was not at the time when he's looking at it.
And I think Judge Mason asked you this yesterday. They didn't go back and redo the lineups again, right?
I don't believe that they did, no.
Okay, sir.
There were 2 lineups, one for Philip Campbell and one for Lamar Johnson. That's my recollection. Now, Nickerson would know better than I.
Do remember, you were I mean, it's a long time ago, Mr. Warren, and it's even difficult for me to learn all the facts recently, but there's a lot of facts in this case. Some of them are real simple. Let me ask you whether or not you agree with some of these facts. At the time of the shooting, Boyd lived at 3910 Louisa Avenue in
Could
St.
you
Louis.
speak into the microphone?
Yeah.
I'm not hearing you.
Yeah. Marcus Boyd was shot and killed on October 10, 1994. Is that a fact that you agree with?
I don't understand the relevance objection.
Well, Your Honor, I believe that Mr. Weiss is reading the stipulations that were proffered to the Attorney General's office and asking Mr. Warren if he agrees with the proposed stipulations that we did not agree to stipulate to.
That legally is irrelevant. He's asking the witness as to a specific fact. It has nothing to do with you. As long as he has a good faith basis for his question, that's pretty much it. The relevance is readily apparent. I mean, Boyd's the purported victim in this case. So go ahead.
Can I interrupt you?
Sure.
Is this going to be lengthy? Because I have to go pee.
You boy,
Maybe 5
boy,
minutes.
that's about as blunt of a question as witness you have ever
I think
heard.
that's a legitimate request, Your
I
Honor.
think we'll step down for 15 minutes. All right, quarter recess, 15 minutes, Bailey. All right, Division 17 is now in recess.
Oh my goodness.
Real 15 minutes.
Oh, by the way, did you hear him ask the judge? 15 minutes. I like him. He's just like, I'm just gonna tell you how it is. But then he asked the judge, is that a real 15 minutes? Judge says yes. No. We all know it doesn't happen that way. Because they don't come back. I don't believe they come back. I mean, they come back and they're in the courtroom, but I think the video ends before they come back. There's just stuff going on. I thought we might see her say hi. Nope, 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 nope. 15 minutes, my left foot. Witness room. That's a new one. Good one. Oopsies. These attorneys. I can't imagine trying to, well, he's not cross-examining him, but in a way, he kind of is cross-examining him because it was his case to try. Oh, we get closed captionings back. Hallelujah.
All right.
Stop talking,
Good.
though. Yes. 15 minutes of nothing. My hair today. Good, yucky. It's like very humid out. That's my excuse. Oh, I do kind of like her little white jacket and black dress. That looks nice.
So as I recall, what the testimony was, Mr. Warren, you were at the trial, that Elking and Boyd were sitting on the front porch. Two perpetrators came around the side of the building. So at one time, it was Boyd and Elking on the porch. The two perpetrators went up on the steps and shot Boyd, who was on the porch. You read that's what happened?
I'm not sure it was that cut and dried. I think there was some discussion or argument between Marcus and either Lamar or Philip Campbell.
And Judge, for clarification, I believe that is an oversimplification of the facts.
Well, you're right. It's now cleared up.
That's
Okay,
them
so we
doing.
got a dispute, I guess, as to what happened on that porch, but that's okay. Were there four people there?
Let me make your life easier.
Sure.
If you wish to dispute the testimony of either Mr. Elkins or Bowen, was that his last name?
Howard,
Howard.
James
I'm sorry.
Howard, Your Honor.
James, I don't know where the name Bowen came from. Of either Mr. Elkin or Mr. Howard. If you want to dispute the testimony of those two fact witnesses, all right, the time to have done so would have been in their cross or by putting on a witness from the stand who is competent to contradict him. Since this witness, of course, wasn't there, all you can really do is, if there are predicate facts that this witness needs to agree to in order for you to tee up a relevant question, that's fine. Lawyers do that. However, if your only concern is to have the facts asserted in your request for stipulation of facts to be agreed to, I think at this point in time, if you can't work it out directly with them, then that means they're going to put you to your proof. And I don't know if you can get proof from this witness.
Your Honor, I agree. I'm just, I don't dispute the testimony of Helkingen and James Howard. They testified. What happened?
You what?
I don't dispute the testimony of Greg. He goes by Greg Elking. Everybody knows that. His full name is James Gregory Elking.
So what might be easier is to simply ask him a "were you aware at the time" type of question, because he may not have been aware.
I will ask him a simple question. Were you aware at the time of the trial what actually occurred on that front porch?
As related to me, I was not an eyewitness.
Yeah. Judge, I'm not going to spend more time with Mr. Warren to direct simple facts that I think the testimony in this case
Speaks for itself.
speaks for itself. Correct, Your Honor. So I only have a couple additional questions. So after the trial and conviction of Mr. Lamar Johnson, did you learn that Philip Campbell actually signed sworn affidavits saying he was involved in the crime and not Lamar?
I found that out when this all started unraveling in 2019. I then found that he had made a sworn statement to the judge that he, Philip Campbell, and Lamar Johnson were the shooters. This was sworn under oath to the court before this affidavit, which materialized 10 years later.
You're referring to when he pled guilty, right? Campbell pled guilty.
Yes, sir.
Yeah. And that transcript, they've got to ask you about that, and we'll look at that transcript.
Okay.
But other than that, did you learn that that Philip Campbell had filed sworn affidavits subsequently to his sentencing, that he...
Not until approximately 10 years later.
Okay, but you did learn that he had filed affidavits
Sure.
claiming that he was participating in the killing of Marcus Boyd along with James Howard.
Signing that affidavit did not make it true, but yes, he did sign a document to that effect.
You know, I have a question. I need to think for a minute if I think the question has any real relevance. And given your years as a prosecutor, I guess your answer could be anticipated, but I just want to ask you, are you of a mind that in a case this serious, there can be no concerns about absolute innocence if the people who say that a defendant was innocent are all people with criminal histories? Because some people are of that mind, and you know, no crime in thinking that way. I'm just curious as to where your head is.
Well, it was a multi-part question. Am I of the belief that pure innocence should establish exoneration? Absolutely.
But what about when the evidence just comes from people who have criminal histories?
Well, I think just like a jury, I would need to determine their credibility. And if they have prior convictions, that, according to the rules, can be used to determine their credibility. and the fact that there is a conflict between an affidavit 10 years afterwards versus 6 months after the event, or 6 months after Lamar's trial, yes, I would think that that's could be weighed. The fact that who's a BA comes in also 10 or 20 years later. Number one, he was underage at the time. He could once he got a life with no parole, he could not get a single day more in jail. He couldn't get the death penalty because he was of underage. And on top of that, he was probably the stature of any normal 16, 17-year-old kid, which should not have been confused with that of the stature of Philip Campbell.
So you're basically would have dismissed witness Howard on the grounds that he has absolutely nothing to lose by lying. That's how you would look at it.
In addition to which, he was established to be a childhood friend of Lamar Johnson. And that affects his credibility in my eyes.
Nope.
Your Honor, at this time, I'd like to just move for admission of exhibits 82, 44, 183-1, 183-1. Let me start out again. Exhibit 82, 44, 183-1, 183-20, 158, 159, 160, 162, 163, 164, 166, 167, 168, and 169. Those are all the exhibits that we showed to Mr. Warren this morning.
Okay. I think you hit everything on my notes, but counsel for the Attorney General's office, any objections to the admissibility of those exhibits? All right. You may consider them all to be in evidence.
The only comment I have, Your Honor, is Mr. Warren, his testimony is over the day, would like to stay in the courtroom. We do not intend to call him a rebuttal. So our examination of him, I have to cross.
You said you have no objections to him staying in the courtroom.
We have no objections.
All right. We'll see how the Attorney General's office feels after their examination is over. Counsel for the Attorney General's office, you may proceed. You may.
Oh, seriously.
Use the microphone.
George.
Microphone.
George, I'll let you in on a little secret. When I was younger, teenage, like 16, I was riding in a car with my friend who was driving. And we had dinner earlier and we were just, driving around like teenagers do. And I'm not going to say she burped, she belched. And then she told me what it tasted like. And she had to pull the car over because I literally got sick. I can't. I'm not as bad as I used to be at that, but I can't. Ugh. Nope. No. So I think we have this dude, and then the next witness after him is Lamar Johnson. I am not prim and proper. Just I just can't do that. I just can't do that. Oh, sorry, I had you muted, young
You
lady.
testified that you were. Thank you, Your Honor. Good afternoon, Mr. Warren.
Hello.
You testified that you were an assistant circuit attorney at the circuit attorney's office back in 1994 and 5 as the chief homicide prosecutor. How long were you employed with the circuit attorney's office?
Approximately 40 years.
After your 40 years spent with the circuit attorney's office, did you continue practicing as a prosecutor elsewhere?
In 2019 or 2020, I became an assistant prosecutor for Butler County,
Okay.
Missouri.
Are you still employed by Casey Proctor, the prosecutor there?
I am.
All right. So how long in total have you been a prosecutor, sir?
Well, 50 years, no, that includes the police time, 45 years.
Okay, and you
At
said
least.
that includes the police time. Were you employed prior to being a prosecutor in law enforcement?
Yes, I was a police officer for the city of St. Louis while I went through law school.
All right, and how long were you employed with the City of St. Louis Police Department?
4.5 years, almost just shy of 4.5 years.
And Mr. Warren, you testified about the process that you would undergo whenever you're reviewing a case for requesting a judge issue a warrant. Is that correct?
Yes,
And so your testimony was that and correct me if I'm wrong, a detective or officer applying on the case would come to you in your office. Is that right?
I'm not sure I heard you.
Your testimony was that a detective or officer applying for the warrant on the case, they would come to your office
Yes,
and they would bring whatever information they had.
yes.
And it was common for them to either bring a witness or victim along as well. Is that correct?
I heard it was common and then I didn't hear.
I'm going to try better to speak directly into the mic.
Thank you.
Slow it down. That'll nail it.
Thank you, Judge. You said that it was also common for the officer or detective to bring with them either a victim or witness involved in the case. Is that correct?
Is that for the warrant application or are you
Yes.
still talking about the search warrant?
No, I was only ever talking about the warrant application.
Okay, yes.
I gotta tell you, sometimes being the youngest one in the room sucks. Sorry, lady. But I think you're the youngest one in the room. And you just got mansplained twice, at least. Oh, I feel bad for her. I feel bad. She's standing in front of two older gentlemen who just want to teach her things, I guess. Work things, of course. Don't be going anywhere weird.
And whenever you would meet with these individuals at the warrant application, you would have an opportunity to speak to them alone.
Yes.
And that was at your discretion?
What's that?
Was that at your discretion?
What's that?
Were you required to meet with them alone, or was that at your discretion?
No, I mean, sometimes I would, sometimes I wouldn't.
In 1994, October of 1994, approximately how many warrant applications had you completed?
From beginning to then,
From the beginning of your time as a prosecutor to then?
I don't know, 5,000, 10,000.
Okay. So is it fair to say that you had met with thousands of victims or witnesses and assessed their credibility?
Oh, yeah.
And on November 5th of 1994, you testified that you met with James Gregory Elking at the Circuit Attorney's Office.
November the 5th, what?
1994. I think I might have said 5.
What was I supposed to have done then?
Is that the day that you met with James Gregory Elking in your office?
I had James Elking in my office on that, I guess on that date. I don't have a calendar in my brain.
And you testified that you spoke with him individually?
Probably.
Yeah, well, yes, directly from me to him. Was anybody else in the room? I don't remember. I'm trying to think. This was 1994. Where was my office? My office was, I think, just in this building. We just moved.
Okay. And so you had an opportunity to meet with him,
Yes.
ask him questions,
Oh, yes.
assess his credibility,
Yes, ma'am.
and at no time during that meeting did he falter in his identification of Lamar Johnson.
That's correct. He explained why he had not identified anybody in the lineups.
And he explained to you that he was fearful. He was fearful.
Fearful, yes, yes.
And based on your conversation with Mr. Elking, you felt confident in his identification to move forward on prosecution of that case.
Yes.
And at no
Now,
time,
hold on. If you want to go down that line, because the wording of your question probably implies a lot more than supported by the facts developed at this point. Because you were dealing with a witness at that time, is it not true whose only basis for identification was recollection of something in the eye that he thought was a little different than normal.
Yes, sir.
So there was nothing else.
He was positive.
That wasn't my question. There was
Well, I'm not
nothing else.
understanding your question, Judge.
There was nothing else. Was there anything else besides, I see the eyes and I think that's the person, that's my view. Anything else?
The fact that he was admitting that he was there for a drug deal.
No, that wasn't my question. I mean,
Well, you
talked
asked if there was anything else, and I
we're talking about
enumerated that.
identification,
Yes,
all right? Identification.
which goes to his
When
credibility.
he made his identification, I didn't ask that question.
I'm sorry,
When
I'm
it
not
came to
following
his
you.
identification, he told you and the officers that it was based upon him looking at the eyes because that was all he could see. Isn't that correct?
I believe so.
And he told you this based upon an identification that occurred in the middle of the night. Isn't that correct?
Middle of the night, 10
Yes,
o'clock or
9
so.
o'clock at night.
Okay, I wanted to make sure that you and I were on the same wavelength.
9
as to
o'clock
what
at night.
Middle of the night meant.
9 o'clock at night.
Okay.
And did he or did he not tell you that all of this happened, I believe, that he described to the court, within seconds?
Yes. Yes.
And that's what you decided was sufficiently liable to seek a murder conviction.
To take it to a jury. Yes, sir, I did.
Oh, because as you told me, let the jury decide.
Well, I'm hearing the fact that you don't find that credible in your tone of voice.
I'm asking you a
That's what I
question.
did. That's what I did
I'm asking
because
you a question.
I did not believe that, believing the witness, that I should just ignore the fact that he was positive of his identification and let a murder suspect go. That's why I came to my
All
conclusion.
right? Because when I ask you open-ended questions like this, you have absolutely every right to fully explain. That's what I'm looking for.
That's what I'm trying to
You
do.
make it too hard.
Thank you, Your Honor. And you testified either yesterday or today on direct examination that you attended a deposition for Mr. Elking. Is that correct?
Well, I would say so, but I don't know what you just asked.
Did you
Can I
test?
see your lips as well
Does
as
that
you?
help?
Yes.
Okay, is this better?
Yeah, I think.
All right. Did you testify that you attended a deposition for Mr. Elking?
Yes.
Okay. And during that deposition, was he asked, if you recall, was he asked if anyone told him who to pick in that lineup?
I would believe so, if not by me, at least by David Bruns.
Okay. And during that deposition, if you recall, was he asked about the timing in which he identified someone?
I don't know, the deposition would speak for itself. I don't recall line by line what was asked and answered.
Okay, but you were present for that deposition.
Yes,
May I approach, Your Honor?
You may, counsel. Assuming to refresh recollection.
I was going to show him the deposition transcript, Your Honor.
All right. But I'm assuming it's to refresh recollection.
Yes, Your Honor.
All right.
I'm going to show you what's been marked for identification as exhibit EB. And I'm going to point you to page 38, starting at line 25, and then going on to page 39, stopping at line 12. I'll ask you to read that.
yes, stop it at line 12, okay?
Yes, sir.
Yes,
Does that refresh your recollection of what was asked and answered at that deposition?
yes.
And what was Mr. Elking's answer whenever asked about when he identified who was in that lineup as Lamar Johnson?
I don't recall exactly what he said. It was after line 12. And I didn't review past line 12 at your instruction.
Are you trying to say you don't remember what was said?
Yes, that's what I'm saying.
Do
I
you
know-
think looking at that transcript will cause you to remember?
Yes, sir.
All right.
Would you like to review it again, sir?
No.
May I approach, Judge?
You may.
And just, I'm going to re-ask the question before you review this. My question to you
Well, you know, the appropriate tactic is to simply let him look at it, and then you inquire as to whether his recollection has been refreshed. Now, you can direct him to a particular line.
Well,
That's
I
fine.
just think he might have forgot the question, the original question that I posed to him, which was, at what point did Mr. Elking tell Detective Nickerson who he was identifying in the lineup?
Oh, I did not realize that was your question.
Okay.
After the lineup, I don't know that he specifically said where he was, but it was definitely after the lineup when he said that to use Charlie's phrase, F up. He said, I actually know who did it.
Okay, and that was after the lineup, they were no longer in front of the in-person lineup, is that correct?
Correct.
And do you recall if Mr. Elking was asked that same question at trial?
I believe he was.
And do you remember what his answer was to that question at trial?
You have the trial transcript there with you?
I do, Your Honor.
All right.
Again, 20 some odd years later, 26 years, I don't have an independent recollection, but I do know that I reviewed the transcript and that was accurate.
Okay, would it help refresh your recollection to review a portion of that transcript?
Yes.
May I approach, Judge?
You may, Counselor.
I'm going to show you, beginning on page 170 of the trial transcript, starting on line 17 and continuing to line 17 on the very next page.
Well, George, and I guess I looked elegant mowing my yard yesterday. There was it.
Does that help refresh your recollection?
Yes, ma'am.
Do you need me to re-ask the question?
Please do.
Okay, so my question to you was Mr. Elking asked at trial when he told Detective Nickerson about who he was identifying in the lineup?
The same thing he said in the deposition. That was after the lineup. I
And did
think
he
he said in a
indicate,
room.
did he indicate why he waited until after the lineup at trial?
He felt that he was intimidated by the people that he was looking at in the lineup.
Was Mr. Elking ever identified in police reports by name, to your recollection?
I don't think so.
Was he treated as a secret witness by the state?
Yes, when he had his deposition, for example, the deposition was titled Deposition of Secret Witness. Maybe had a first name, I'm not sure.
And do you recall at any point there being a motion to compel for the identity of secret witness throughout the course of the prosecution?
I don't remember that, but I would have opposed it.
And if there was a motion, okay, so you say you would have opposed it.
Absolutely.
Whenever Mr. Elking was deposed, did you produce him for that deposition?
I did,
Why?
because I didn't want the defense to know where he lived.
At that point, had you told the defense that he was a protected witness?
Yes. Well, I'm sure I would, because that's why I went to fetch him.
I'm glad you asked that question, because I need to ask you then, before the deposition, the defense attorney would have been advised that this was a protected witness.
Well, yeah, and the fact that we were relocated him and weren't giving out his identification.
All before that deposition.
Yes.
During the course of the deposition, to your recollection, did the defense attorney inquire as to the details of this relocation, what it was about, what the witness was and was not getting, all of those matters?
Well, as to his relocation, he started to, I think, in fact, he did ask where he worked. And I objected. I think we went off the record and he abandoned that because we talked about him being a, quote, protected witness.
Right.
And he abandoned that approach. As far as what he was promised, I'm pretty sure that was in there. Again, the transcript itself would speak.
Okay, I'll need anything wherein the defense attorney asked and sought information as to all these payments, the payment of rent, the payment of cost to relocate and move someplace else, everything that was expended for this person with respect to securing his testimony at trial. I need to know.
I apologize in advance for all the people that don't like yellow. That's a lot of yellow. Very bright and springy. And I have a feeling this might take them a minute. Maybe not.
If those questions were asked and if any detail was asked.
Your Honor, I can offer as State's Exhibit VV, I can offer to the court the deposition of secret witness Greg.
No, you didn't hear my words.
I didn't
I want
understand.
just the questions. I don't want the whole deposition.
Understood.
I
Your
don't need
Honor.
the whole deposition.
I
You are
believe-
saying, because if you don't give me the questions, I'm going to assume the defense attorney engaged in ineffective assistance of counsel. You don't want me to go there. You
Your
want
Honor,
to show me that that did not happen.
I do not believe that there are any questions in this deposition as to the relocation. I believe that Mr. Warren's memory was pretty accurate in that there was a question about where the
Where he
secret
worked.
witness works.
That wasn't my question.
There are no additional questions in relation to the location
thank
of
you.
the witness.
That's what I kind of anticipated, but I want to make sure that the record was clear on the matter.
And Your
Thank you
Honor,
for your answer.
yesterday, I think you did indicate you asked for a copy of this deposition. I'm happy to offer it as State's Exhibit VV.
Yeah, offer it, but that was why I was wondering
Okay,
how, because I just heard from the state that this was essentially flagged to defense counsel. And defense counsel, perhaps out of ignorance of what goes into relocating a witness, did not delve into the degree to which one could argue that the witness did or did not receive benefits that under cross-examination before the jury could cause the jury to say, well, maybe we shouldn't trust what he says beyond a reasonable doubt, since this was the key witness.
yes, Your
It's a
Honor.
big deal.
I will offer it then as State's
All right,
Exhibit VV.
thank you.
He treats her like she's still a law student. Maybe she is. I don't know. I don't know.
Can I say
No,
something?
Mr. Warren, I just want
He
to,
said, can you say something?
oh, I
You go
didn't
right
hear you,
ahead.
sir.
All right. Relocation is always going to cost money. You can't relocate a person without spending some money. David knew that we had relocated him. It's implied, it costs money. How much? Heck, I didn't even know. So I don't think that question that the judge proposed could have been answered at the deposition or even at the trial time.
It could have been asked.
Could have been asked.
Yes, surely
It could have been asked, but the answer would
And
have
even
been, I don't
competent
know.
judge would have allowed it on the cross-examination because it goes directly to credibility.
But the question is,
How much
Can-
money did you get?
and the answer is no, and the law says that the question is not evidence, it's only evidence of the answer to the question.
Boy, are you wrong. Go ahead.
Well,
Let me ask you this, Mr. Warren. Do you recall at trial any questions being posed to Mr. Elking about him being relocated by the state?
I don't recall, but again, the transcript would speak for itself.
And as a prosecutor, the chief homicide prosecutor at the city of St. Louis, if a witness who had been relocated was asked about the relocation, would you address that on a redirect examination?
Now you're getting a little in the speculative zone because we don't know what the answer could have been. Let me make sure you understand. The defense attorney, if he has knowledge of basic reasons why the jury should not believe a key witness, has a responsibility to inquire into that. If Mr. Warren is correct, the word relocation should have triggered in the mind of Bruns the possibility of money being expended, then that's a question that should be asked. It's kind of like if a witness says, I was paid a fee. Then the person cross-examining witness says, how much were you paid? How reasonable is that fee? And then the jury can hear this, and the jury can say, well, this relocation stuff really helped change this man's life. He had nothing. And now that he got all this relocation assistance, he got some help off to something. That's something that the jury can take into account. Any suggestion that they can't take into that account is wrong under the law. And any suggestion that those questions could not have been asked at trial is wrong under the law. And any suggestion those questions could not have been asked at deposition is wrong under the law. The issue for me is, should they have been asked, to the degree that a potential constitutional violation has occurred? I think I'm clear now.
Yes, Your Honor, I
So
understand.
ask questions in light of that. Let's not go off on things that really don't matter.
Thank you, Your Honor. So I wanted
you for
to kind of
yelling.
move over, Mr. Ward. We were talking about the witness, Mr. William Mock, and quite extensive testimony about that this morning. My question to you is, back in 1994, was it common practice for you to provide your investigator with the names of witnesses you intended calling at trial?
Yes,
And do you know what system or database your investigator used to run the criminal history?
do I know what?
What database was used?
No, I was, maybe Regis, maybe Mules, I don't know. That's something that I never was able to master.
Okay. And so then after you would provide that information to your investigator, how would he give that back to you?
He would tell me, witness 1 has no record. Witness 2 has some arrests but no convictions. Witness 3 has these convictions of a felony or misdemeanor. And that would be him telling me, and then I would pass that on to the defense attorney.
Okay. And your memory is that you did that in this case? Your memory is that you did that in this case?
Yes, yes. Mhm.
And are you aware if that, whatever database was used, could search criminal history nationwide, or was it statewide, or do you know?
I don't know. We used to have what was called a Hoover sheet, which was an FBI sheet, and that would have supplied some sort of federal umbrella. If they use Mules, I think that I know from personal experience recently that Mules gives out-of-state convictions, but I don't know what it did in '94. So I hope that answers your question. I certainly want to answer it.
It does. And do you recall if at the voir dire portion of trial, if you introduced or questioned potential jurors on the fact that they would hear that witness had several prior convictions?
I believe I would have. I normally would.
Would it help refresh your recollection?
Yes,
I just
ma'am.
need to know if those prior convictions came out at trial.
Do you recall the trial testimony about his prior convictions?
Yes, ma'am.
And what was that?
Mr. Mott said that he had several convictions and he enumerated them, the same ones that I had given to Mr. Bruns. He also added, I got something in California. I don't know whether that was at the deposition or trial. And he also added, and I had some other minor convictions with the loss over the course of years. And that was what was presented to the jury.
And as far as Mr. Mock, you testified in excess this morning about letters from Mr. Mock to you that you hadn't seen, some that you recognized, and there was also the letter that you wrote to the parole board. Is that correct?
Yes.
And at the time of trial, on July 10th, 1995, had you already written that letter to the parole board, or at least drafted it?
I don't know. What's Mr. If Charlie could give me that paper again, I would read off the date on it.
Well, do you recall asking Mr. Mock at trial if he expected you to write that letter and inquiring if he had in fact seen that letter that you wrote?
You had compound there. What was the first one? If what?
Do you recall asking Mr. Mock at trial if he had seen that letter?
I don't recall asking him that. No.
Okay, would it help refresh your recollection to see the
Yes,
trial
ma'am.
transcript? May I approach your honor?
You may, Counselor.
I'm gonna
Again.
show you.
30 years ago.
You can-
Probably doesn't remember what he asked. Oh, I don't disagree, George.
Page 249.
He's just been kind of dismissive of her and like
24.
yelled at
Go
her.
on to the next
Well, didn't
page,
yell, but
250, why I'm late.
That is true, but I think more evidence has came out since the trial, with more people saying that it was not this guy. That's why they're relying on what was said at trial.
Okay,
Does that help refresh your recollection?
yes, ma'am.
And can you tell me what the testimony was in regards to the parole letter at trial?
He had asked me to write a letter to the Board of Parole, and that was the only thing, and I wrote it, and it was before trial.
Okay, and in fact, you had showed it to him, is
Yes.
that correct? And that discussion occurred in the presence of the jury. That's part of the trial transcript, correct?
Yes.
Can I have 1 second, Your Honor?
You have 2 seconds.
Thank you, Judge.
You need water? Oh, you got water.
Got some,
I'll just dive over the desk.
Take it down.
All right, Mr. Warren, I just have one last question. You had testified on direct examination that sometime later, after, I believe you said after the motion was filed in 2019 and you were reviewing the file, that you saw a transcript from Philip Campbell's plea
yes,
guilt. Whenever he pled guilty in his case, is that correct?
yes.
And I'm going to show you, if I can approach, Your Honor.
You bet.
I'm going to show you what's been marked as State Exhibit K and ask if you recognize that.
Yes, it appears to be the transcript of, in front of Judge Berger of the defendant Philip Campbell at a plea of guilty.
Okay, and I'm going to take that from you. You had testified on direct that you didn't remember exactly what the dialogue between Judge Berger and Philip Campbell was. Would it help refresh your recollection to review this transcript again?
Yes, I remember generally, but specifically word for word, no.
Okay, and Your Honor, I will inform the court that this is not numbered, so I don't know what page number I'm going on, but I'll proffer the whole thing to the court.
You have, and should, in all honesty, isolate the pages perhaps in your post-trial brief that you think are truly relevant.
Yes, Your Honor. So I'm going to flag to you, I have these green stickies here. You'll just read
That's fine.
from, there we go.
From where to where? Okay.
It's funny, he's been sitting his water up there on the judge's bench this whole time, and then this time the judge was looking at him. He's like, "Do you mind?" Because it surprised me that that's where he was putting his water bottle, the judge's bench. And George, I don't blame her for the mistakes that's being made. I blame the woman sitting beside her should have helped her and told her that, hey, put these in there, or do this or that.
Okay.
So she didn't have to get in front of the judge and him be able to kind of do what he's done to her. Hello.
I'm going to ask you a question about that in just a second. But prior to that guilty plea, you were still the prosecutor on the case. Is that correct?
Up until the time I left for the military.
So on June 26, 1995, were you still the prosecutor on Philip Campbell's
No, ma'am.
case? When did you leave?
Like I said, I remember definitely flying out of the United States on Christmas Day.
Of
We would have been
1995?
active, ma'am?
Of 1995?
Yes.
Okay,
We
so
would
my
have been
question was
active
on June 26, 1995, you would have still been in the circuit attorney's
in
office.
June of '95. I thought you
Yes.
were talking about, is this the date of the plea of guilty?
No,
Oh, okay, you confused me. All
you're
right.
getting ahead of me.
Okay,
So you were still the prosecutor in June of 95.
yes,
All right, I'm going to show, if I may approach, Your Honor.
You may?
I'm going to show you what's been marked as State's Exhibit J and ask if you recognize that document.
Notice he didn't have any problems with the guy attorney when he wasn't ever at the microphone and none of us could hear him. He didn't have any problems hearing him. I'm glad he told her to use the microphone so we could all hear, but it's kind of aggravating. October 95.
okay.
Which time zone specific?
And do you recognize this document as a alibi defense that was sent to you by Philip Campbell's attorney, Robert Lunt?
Yes,
And this would have been part of the file?
I would assume so.
And Your Honor, I would offer this as State's Exhibit J.
Any objection? This is different? I thought this was the alibi as to, all right, thank you. Please, you may, what's the exhibit number there from your file?
Letter J, Your Honor.
Say that again?
Letter J.
J, exhibit J.
Yes, Judge.
All righty, thank you.
And so, Mr. Warren, you received this alibi defense that Philip Campbell was going to rely on alibi, that on October 30th, 1994, he was at 3957 Lafayette from 7 p.m. until 11 p.m. Is that correct?
Can you do me a favor?
Yes, Your Honor.
Advise the court of the relevance of Philip Campbell's attorney announcing alibi witness.
Your Honor, because the alibi witness in Philip Campbell, and he was charged as a co-defendant of Lamar Johnson, he noticed his alibi at 3957 Lafayette,
All right,
which was houses down from the alibi defense that Lamar Johnson noticed of. So we believe that that would be relevant for
to
argument.
show me what?
To
I
show,
mean, it sounds like these guys were trying to allege in their cases that they were in these two different places and couldn't mix the crime. Why am I to assume they should have both been in the same place?
Your Honor, we believe that it's relevant that Philip Campbell noticed up an alibi saying that he was intending on relying on the fact that he was incapable of committing the crime.
Right,
Someone was going to say that he was with them the night of the murder.
right,
Lamar Johnson noticed up an alibi down the block
right.
from his
okay.
co-defendant.
He lives in a different, or was staying in a different place.
He was visiting a different place.
Okay,
And subsequent to that notice of alibi, Philip Campbell entered a plea of guilty where he said that he committed the murder with Lamar Johnson. And so we are putting before the court those three pieces of evidence.
well, they don't do much because, you're there on him swearing that he committed the crime with Lamar Johnson.
Correct, Your
The
Honor.
alibi thing, that almost hurts you because it's inconsistent. But it doesn't worry me too much because I'm not an issue as to whether or not he should have been crossed on filing an alibi defense and then saying that because he shouldn't, because it was a guilty plea, wasn't it?
Sure, Your Honor. I know,
Yeah.
I trust that the court will give it whatever weight the court believes it deserves, but I'm offering it.
Keep it at one page.
Yes, Your Honor.
All right.
It may be two to cover the plea, but I'll parse it down so it's not a packet.
All right,
So I would offer State's Exhibit J, which is 1 page.
all right, thank you.
I can have just a moment, Judge.
Keep it to one page. Has he told the other side that one time? Keep it to one page. No, I haven't heard him. And he really liked the way that they did their binder and tabbed everything and blah, blah, blah. And he has just given her nothing but crap.
Your Honor, I have nothing further for this witness.
Redirect?
Go to the microphone or we can't hear you.
You may go ahead. Keep in mind that it's limited to the scope of cross.
And you'll be short, Your Honor.
Thank you, sir.
Mr. Warren, I'll tell you that it's a fact, but you can assume this, that the deal that was made with Philip Campbell.
What?
The deal that was made with Philip Campbell.
Okay,
He pleaded guilty to 2 separate felonies. One, apparently the murder of Marcus Boyd,
yes,
and he was stopped in a car with Lamar where there was a pistol found in the car. He apparently wasn't entitled to hold it. So he had 2 felonies he was pleading guilty to. The same felony that Mr. Lamar Johnson pleaded guilty to and got life without parole.
No,
Mr. Lamar
was
Johnson.
tried, wasn't he?
That Mr. Lamar Johnson pleaded guilty to and got.
Well, if
No,
he pled
Mr.
guilty,
Johnson-
then what are we having this for?
He didn't, I'm sorry,
Mr.
he didn't plead guilty.
Hold on, Counselor.
Yeah, let me correct it, Your Honor.
Right, thank you.
Thank you. This is the same crime that Lamar Johnson was convicted by a jury and received a sentence of life without parole.
The same homicide. is that-
Same kind,
Yeah, yeah.
same crime.
Yeah.
This guy has offered a deal for 7 years, plead the first to manslaughter. The second years was 2 years to run concurrent with the first 7 years. So he pleads guilty to 2 felonies. The first one, which got his co-defendant at the time, life without parole. This was a heck of a deal, wasn't it? This is
What
a
did you
heck of a
just-
deal that was offered to Mr. Phil Campbell.
I assume so. It was the second day of trial, as I'm understanding, and Ed Sweeney was without a witness. So he had nothing to present.
What
And
does,
some-
I'm sorry, what does without a witness mean?
Yeah, what was
It
that?
means Elking might have deed-bound, gone away, fled.
So they couldn't find Elkie, so they made this deal with Campbell. Is that what your understanding was?
Is that what?
Is that what your understanding was?
That what?
Your understanding is that they couldn't find Elking, and therefore, for that reason, primarily, they made a deal with Campbell where he only pled guilty to 7 years.
That's what I understand, but that's based on triple, quadruple hearsay. I'm over in Europe somewhere.
I understand. That makes sense, doesn't it?
Yeah, it makes sense that if you don't have a case, you get whatever you can.
Yes.
Jeopardy had already attached, so
And
therefore,
so
the fact that we got that much is surprising.
so if you were a prisoner and facing life,
If you don't have a case, you get what you can. I knew that's what they did. It's freaking plea deals. He just admitted it. Got that guy to plead. He got 7 years. This guy gets life without parole. Yay. No, he didn't get the guy to plead. The other prosecutor did because he was in Europe, Bosnia, whatever. He just said the whole playbook. If you don't have a case, you get what you can. That's disgusting. You're right, George. It's a disgrace. Absolutely. That's insane. At least he's honest. I mean, he's still a prosecutor. He's an assistant prosecutor. At least he was honest about it. Yes, bikini bottom. He's probably seen some bikini bottoms if he's over there in Europe. Yeah, that irritates me. But at least he admitted what we all kind of feel a lot. Alrighty then. Yes, we're no bikini bottom.
without parole, and somebody offered you a deal like this, and you were at the guilty plea hearing before Judge Berger, and they read as they did, Judge, strike that. Mr. Sweeney reads, in cause number 94-376B, the state would prove beyond a reasonable doubt on the evening of October 30, 1994, here in the city of St. Louis, state of Missouri, that at the street location of 3910 Louisiana, the defendant Philip Campbell, acting together with Lamar Johnson, arrived at that location. That 2 gentlemen were on the front porch, on the front porch or yard area of 3910 Louisiana. One of them being the victim, Marcus Boyd, and the other being a white male. That the defendant, Philip Campbell, acting together with Lamar Johnson, caused the death of Marcus Boyd by shooting him and did, the defendant knowing that the defendant's conduct was practically certain to cause the death of Marcus Boyd. Court, and those are the facts that the state would have been expected to prove. Mr. Sweeney, Yes, just let me further state, the state would also prove that the testimony of the police officers and the medical examiner that the victim, Marcus Boyd, died from a final gunshot wound which entered the back of his neck and exited the front of his neck. And that in addition to that wound, he also suffered numerous other gunshot wounds to his body, being the upper part of his body and to his back and the left trunk of his body. 5 separate gunshot wounds to the left trunk and hip area. There was an addition wound to his arm that the medical examiner would testify appears to the continuation of the bullet that entered through his back and a further gunshot wound to his thigh. And further, the evidence would be that the bullets received from both the victim's body and the scene, that there were 2 separate weapons, and the first a 25 caliber and the second a 38 caliber. Now, Mr. Campbell, do you admit that those facts as stated by the Attorney General? Yes, ma'am. Has anyone made any threats or promises to you in order you to plead guilty? No, ma'am. Certainly made a promise that you only get 7 years for a murder and another crime. But anyway, are you pleading guilty of your own free will? Yes, ma'am.
So what's the question?
Would you take a deal like that, 7 years, and just agree to that? I would.
Well, you know,
I have no further questions, Your Honor.
yeah, I see where you're going. That's fine.
Your Honor, can I just correct one thing? I believe whenever Mr. Weiss was reading the pre-transcript, he said, do you agree with the Attorney General, innocent circuit attorney?
After a few thousand of these guilty pleas, I kind of figured that one out. Go ahead. Anything further this witness? Anything, anybody? You can step down, sir.
It's like,
See, I'm looking at 2:20. Is that clock correct? Yeah, it is, isn't it? Yeah. All right. I've heard you guys up a long time before I've allowed you to eat.
2:20. Is that clock correct? It's almost time for dinner. That's what would be said in my house. I couldn't believe it. I can't believe it. They said 9 p.m. was in the middle of the night, and not one of you commented that that's what I would think. I left it for you. I was sitting there thinking 9 p.m. is in the middle of the night. All right, so this dude's, sorry, this guy's done. And I believe that Mr. Johnson is up next. Oh, no. I'm sorry. I was wrong. I was wrong. I actually don't know who this guy is, but when he first started walking up, I thought he was a woman. Stop. I did not tell you to go. I saw this. Oh, you guys can't see that. Or can you guys see that? I don't know. I saw the back of his head, a hair. I thought that was a woman. This is not Lamar Johnson. Definitely not Lamar Johnson. Oh, we see him.
I'll try my best. Thank you.
Counsel, you may inquire.
Thank you, Your Honor. Mr. Bruns, would you state your full name for the court, please?
David Bruns,
How old are you, Mr. Bruns?
58.
Where do you live, sir?
I'm sorry?
Where do you live?
How about in St. Louis City?
I'm going to ask you a little bit about your background and your experience as an attorney, okay?
Yes, sir.
Where'd you go to law school?
St. Louis University,
When did you graduate?
1989.
What was your first job?
I worked for Judge Robert Dowd Sr. As a lawyer, or after law school. I worked for Judge Robert Dowd Sr. as a clerk at the Missouri Court of Appeals for a year.
And after that, what did you do?
I joined the Special Public Defender's Office, which we did conflict work in St. Louis City and County. Our office was in the city.
And how long did you spend as a special public defender?
Approximately 8 years.
And what years were those, if you can tell us?
It's like approximately 1990 to 1998.
So during that year, I think this Lamar Johnson incident that we're litigating today, the trial occurred in 95. Do you remember that?
Yes, sir.
So you were a public defender?
Yes, sir. I
Were
was
you-
in the conflicts office at that point.
Were you appointed to defend Lamar Johnson in the charge against him?
Yes, sir.
And then go on, after you served as a special public defender, what did you do?
I went to the death penalty unit of the public defender's office,
How long did you serve in that position?
3 years.
After that, what did you do?
I've been in private practice in my own firm ever since,
How long have you been in private practice, sir?
since 2001, so about 21 years, 22 years.
And what is your law practice?
Well, I do 99% criminal.
Criminal defense work?
Yes, sir.
Let's talk about the Lamar Johnson case. You were appointed to defend him, right?
That is correct, or assigned in our office, how it worked.
Did you know what the evidence against him showed as far as you were able to see?
Well, in the process of representing him, we would have got police reports, we would have done depositions, and through all of that would have accumulated at the time what the evidence was.
Did you understand that the primary material witness against Mr. Lamar Johnson was James Gregory Elking? He was the person on the scene at the time the crime occurred.
He was the eyewitness.
He was the eyewitness.
Yes, sir.
You understood it was dark the night that Marcus Boyd was killed?
It was my understanding that those were the facts.
Was it your understanding that the assailants that shot Marcus Boyd wore black masks that covered basically only their eyes?
Well, my understanding,
Only their eyes. Thank you, Your Honor.
and that was my understanding, is the mask covered the face except for the eyes.
Okay. Well, you had requested some discovery, I guess, from the prosecutor, right?
Yes, it would have been an office policy at the time that there would have been a request for discovery filed, probably at arraignment.
Did you get any discovery, do you recall?
I know I got discovery. I can't say that I have a specific recollection of like exactly what we got at that time, but we would have gotten discovery over time.
Did you learn that there was another individual charged for the murder of Marcus Boyd?
Yes, I knew that.
Philip Campbell.
Yes, sir.
You didn't represent him at any time, did you?
I did not. Mr. Robert Lunt did.
At any time prior to the conviction of Mr. Lamar Johnson, did anyone disclose or provide to you information that the Circuit Attorney's Office was paying Mr. Greg Elking?
No.
Did you learn anything about the fact that he was in a witness protection program?
So, no, not specifically. I mean, at the time, I don't think there was a real witness protection program.
That's at least that's what you knew in connection with your experience as a public defender.
Yes, sir.
So no one told you that they were paying the rent, utilities, moving expenses, and other such expenses for Greg Elking?
No, sir.
Going to show you what has been marked for identification as Circuit Attorney Exhibit 16. And ask you, if any of that information is provided to you to the best of your recollection and knowledge.
I would have received no information about payments for anything about any direct payments or indirect payments that were made.
Let's assume when you requested discovery in this case, which was done before trial, right?
Yes, sir?
You learned that payments were starting to be made to Mr. Elking as of 11/4/1994.
I'm sorry, before trial?
Before trial, yes, Your Honor. Mainly the payment started on November 4, 1994. Let's assume you learned that more than $4,000 worth of payments and expenses were paid to Mr. Elking or to his wife or paid his bills. Would that have been valuable to you as a defense attorney in the cross-examination of Mr. Elking?
Yes. Looking back, I believe that I would have cross-examined him on it, because if he's being compensated in a way for testifying, I think there are jurors who might disbelieve and might give him a motive.
Would you vigorously cross-examine him?
I think that's probably for others to say, if I can vigorously cross-examine anyone, but I think that I would have gone over, because it's a motive, and you're looking for, when you have what appears to be an impartial witness, you're always looking for a motive about why they are saying what they're saying.
That would have gone to his credibility, wouldn't it?
It goes to his credibility and his motive to testify in the way that he is testifying.
And as a defense,
So if you got lost at the beginning, this is Lamar Johnson's original attorney at trial. So I don't know why in their opening they said $250, and then just now they just said $4,000. Huge difference.
attorney back then in '94, and even today, would you consider that information very material to the defense of this case?
It would have been material. And it is my belief it would have been used.
Did you also learn that Mr. Elking had gotten a number of traffic tickets, and they were also taken care of prior to the trial?
I did not know that.
If you had learned that, would that be additional information you could have used to impeach or attack the credibility of Mr. Elking?
I could have.
Would you have?
I think that's hard to say sitting here 30 years later, but it's something that I would have considered using. I think it depends the extent of the traffic tickets, and
Okay.
I think certainly in certain situations it could be used.
Now, at some point in time prior to trial,
A list of tickets, how much money the fines and fees added up to?
the only thing I discovered, Your Honor, was that note that had 3 tickets
Just three, okay.
just the three that were not
So
across.
at least know the three,
At least no three.
and there was some concern that he might be arrested. Is that correct?
He had a lot of tickets from what I understand, and he was concerned that the police who stopped him were going to take him down, arrest him and take him to city jail. And then he testified, he told him to call Detective Nickerson. And he did, and you heard Dwight Warren said, yeah, he learned about it and got involved with the city councilor's office, and whatever they did with the tickets, I don't know.
Well, let me ask you this, Mr. Rogers.
Yes, Judge.
If you became aware in this case, that the witness had secret, or at least a suspicion now that he was concerned about being arrested, and further, that the prosecutor, who was the lead prosecutor on the other side of the case against you, had taken steps, whether successful or not, to eliminate those things, have them set aside for the witness. Is that something you would have questioned for this morning in cross-examination?
Probably is what I would say, is that I think that I would have, and it also sounds like to me that there's probably, that if you're scared of being arrested, that there's an arrest warrant out. And that is also because to get rid of the arrest warrant, not only do you get rid of the ticket, you probably went and got the court to withdraw the warrant. And that is a definite immediate motive to want to cooperate, because generally people don't like to be arrested, especially in traffic court.
I want to talk to you also about Mr. Mock. Did you learn that Mr. Mock was going to be a witness, Mr. William Mock?
At some point, I did in the course of representing Mr. Johnson.
And I gather you took his deposition in the case?
I can't say that I have a specific memory, but I saw a copy of it today. So I do believe I did.
Did you learn that Mr. Mock was a jailhouse informant, that he had been in not cell, but the area with Philip Campbell and Lamar Johnson?
I don't remember Philip Campbell or any of his involvement in that. It is my recollection that he stated that he was confined with Lamar Johnson, and that there was some discussion, and that he overheard a statement from Lamar Johnson.
Do you remember that you learned that there was no Lamont in the cell area where Philip Campbell and Lamar Johnson were confined?
It is my recollection that we did investigation, because in the discovery, it mentioned that there was a Lamont, and that we could find no Lamont that was confined.
On those days?
On those days with Lamar Johnson.
In the deposition right before trial that you took of Mr. Mock, did you ask him whether or not he'd ever testified in a criminal proceeding before?
After reading the deposition today, it is my recollection that I did.
What did he tell you?
He told me he had never been a witness in a criminal case.
Did you ever learn that in 1992, he did testify in a case in court in Kansas City, in which he testified that his cellmate had basically confessed to a vehicular homicide?
I did not learn any of that before trial. The little knowledge that I have of that was told to me in the last 2 or 3 years.
What, if anything, did you do to investigate the criminal history of Mr.
Well, excuse me, before you go to that, I'm waiting to see what the next question will be. I need to ask you, you weren't aware that Mark had this prior act of testifying that fellow inmate said something that incriminated someone else. Had you known, is that something you would have at least attempted to cross-examine?
I believe so. It makes him someone who gets in trouble that then tries to get information or make up information or do whatever to get himself out of trouble. And so I certainly, either I would have cross-examined him on it, and I certainly would have investigated it, especially if you can find out that that original testimony is false in any way. But I think just the fact that he did it, I would have used it.
Sure. What did you do, if anything, to find out the background or criminal history of Mr. Mock?
I can't say that I would have said that I did anything specifically. What happens is, under the rules of discovery, is the state has the obligation to turn over all prior convictions of misdemeanors and felonies that a witness for the state has. And so I would have received that, or should have received, a complete criminal history. I will also say this was 1990 something, where there wasn't CaseNet. You couldn't even run someone in CaseNet then for even their Missouri convictions.
So do you recall that basically you were advised that there were 3 felony convictions that Mr. Mock had?
I do not remember what exactly I was told. I will tell you that I would have cross-examined on every felony and probably all misdemeanors convictions that there were. And if I didn't cross-examine him on them, it's because I did not have them.
Going to show you what has been marked for identification as Exhibit 227. This is a summary number of convictions that Mr. Mock had prior to. Sure, sorry. I'm going to ask him whether he was aware of the number of criminal convictions that are depicted on this summary.
Doesn't that go to the weight?
I just wanted to point that out. We talked about that in
Yeah,
at the bench
but,
conference. And I don't.
you know, established that in your commentary, you know, that's the question that's that. They have to go to the weight, and unless they stipulate the fact on that, that is, I mean, I don't really need a whole lot of paper for my conclusion that this individual has a particular history. This is really more about what this particular witness did or did not know, or how it may or may not have affected his judgment and strategy of the trial. So if you objection, I'm gonna have to.
I'm sorry, sir, if you could go back to the question.
Sure. Were you aware of the extent of his criminal history? That's reflected here in this summary on Exhibit 227.
So my understanding today is that I cross-examined on 3 felonies, and that is the information that I would have had access to at the time, where I would have cross-examined on any other either pending or conviction, or at least tried to do on the pending felony. It's more complicated, especially at the time, whether you could cross-examine on a pending case, especially if it was out of circuit.
Sure. Were you aware at any time prior to not today, but at any time after the conviction of Mr. Lamar Johnson, that William Philip Mock was sending letters to Dwight Warren?
I don't believe I was aware of letters that were sent.
I'm going to show you exhibits 158, 159, 160, 162, 163, 166, 168, 169. Whether or not you knew that these letters were being sent by Mr. White-Warren, not by Mr. Mock to Dwight Warren.
So I do think this attorney he seemed like he's a decent attorney. He didn't have ineffective counsel by any means. Enjoy that Diet Dr. Pepper there, lady. Uh-oh. If there was a spinny circle moment in here, I didn't catch it. Or if it is, it's not very long. Maybe they should quit moving their cursor all over the screen. That's them. There they go. They're going to switch feeds. There you go. Unmute it. Good job.
That Mr. Warren was gonna write a letter saying what he did to the parole board after trial. And I mean, he wouldn't do it before trial, because if he got paroled, then they wouldn't need Mr. Warren anymore. It's just how that sort of works.
I'll show you with the marked identification previously as exhibit 99. This is the letter Mr. Warren wrote to Mr. Vicky Myers, NYDORS, dated June 26, 1995. That was before trial. Did you ever see that, sir? Prior to trial?
No, sir.
Basically, they had three witnesses at trial. Is that your recollection? A witness, Mr. Ralph Campbell, a detective, who apparently testified to a remark made by Lamar to him while he was waiting to view the lineup, or down waiting to be in the lineup. Was that one of the pieces of evidence you recall?
Wait, and I'm sorry, one of the people was Mr. Mock? Was that your question?
No.
Okay.
One of the witnesses for the prosecution was a detective, Ralph Campbell.
Yes.
Okay, and the second was Mr. Mock.
Yes.
Both of those testified they overheard Mr. Lamar Johnson say something with respect to a white guy, right?
Wait. So I don't remember the substance of the statement that Detective Campbell testified to.
I think he testified that Mr. Lamar Johnson remarked to him, "You should have never let the white guy live." Remember that?
I do now.
And there was nothing in writing on that, no recording, nothing, right? Just his testimony.
My remembrance is it was written in a police report by Detective Campbell or whoever wrote that report, that's what they overheard him say. And that at no time did they have any recordings or written statements or anything from Mr. Johnson.
Okay. The next thing, they had a statement from Mr. Mock, who apparently overheard talking jail between Lamar, Mr. Campbell, and Lamont. That was the next thing, right?
That was yes, another piece of the evidence.
And they had the eyewitness testimony from Mr. Elking.
That is correct.
And as I recall, his testimony is he was able to pick out Mr. Lamar Johnson, but it had something to do with his eyes.
I think he mentioned something about a lazy eye, but it was some sort of something about the eyes, is my remembrance.
After trial, you filed a motion for new trial, right?
Yes, hopefully timely too.
Apparently you had learned that Lamar had received some letters while in jail, city jail, before he was sent to prison or sentenced, from Mr. Phil Campbell, right?
I did learn from Lamar, I had to have, because it's in the motion for new trial, that there were letters that he had received. And yes, I believe that those letters were from Mr. Campbell.
Did you learn, after learning about the letters from Mr. Campbell, I gather you put something in your motion for new trial regarding them, right?
That is correct.
At that time, had you actually seen the letters? Do you remember?
I don't think so, but I don't know for sure.
And did you learn that they were being subpoenaed from Mr. Lamar's cell?
I learned that in my recollection after the fact, and I don't know if it was a subpoena. I actually think that there was a search warrant that was done on his cell, but I just don't, I don't know the facts for sure.
Yeah.
It was 30 years ago almost.
So I call it a subpoena, but I think you're right. It was probably a search warrant.
And I would have learned of a search warrant for sure after the fact. Mr. Warren would not have told me beforehand.
Did you ever get a copy of those letters?
I believe that at some point that I would have gotten a copy of the letters from Mr. Warren, but I have no direct recollection.
I'm going to hand you Exhibit 2, which I represent to you as a copy of 4 letters. Put the first one up.
For the record, I hate these letters.
The first letter in that batch
He's not
of
saying
letters
no.
we put up on the board here. We looked at it this morning with Mr. Warren. It's written by Phil. Do you recall reading those letters? If you recall, take a chance, take a look at them now.
The first letter, I don't have a specific memory of.
Do you remember how you used those in motion for new trial, if at all?
After seeing my motion for new trial, it's my belief that I put a point in there on them, but I have no specific memory.
Reading them today, as you have doing now, you believe that they are significant information regarding what happened and that Lamar Johnson was not involved in the murder? But rather, Phil Campbell and James B.A. Howard committed this crime.
So I don't know that I would have known at the time who BA is, but when I saw that reference, but it is, I mean, they are what they are. There's someone who's saying that you didn't do it and that you got convicted for something that I did with someone else.
Let the record reflect the witness spent a couple minutes reading those letters
I-
before giving that.
One place to store your pencil.
At any time before the trial of Lamar Johnson,
You saw
were
it
you
too.
informed that the St. Louis Circuit Attorney's Office, that Mr. Mock, William Mock, was seeking a reduction in sentence from Judge Donald Mason in his own criminal case? Donald Mason, not David Mason.
No,
Were you aware that Mr. Mock was seeking a pardon from Governor Carnahan?
no,
Were you aware that Mr. Mock was seeking a reduction in his status within the Department of Corrections so that he could enter a drug treatment facility?
The correct word is security status. Sorry.
Thank you, Your Honor. I don't have your experience up there.
I don't remember any of that information. I don't believe I ever received it. It is my belief I didn't cross-examine him on it. And if I would have had it, I think I would have used it because I was looking for anything to go after Mr. Mock.
I understand. Did you learn what Mr. Mock was doing in the St. Louis City Jail? What was he here for, you remember?
No idea.
Hello? Did he go to sleep? Well, his hair's trying to escape. It's not as bad as a comb over, though. Hello. Hi. No, ma'am. They are not muted.
At any time in your involvement with Mr. Lamar Johnson, defending him in his trial and the motion for new trial, did he at any time indicate that he had anything to do with the murder of Marcus Floyd?
No, never.
I'm going to hand you next what has been marked for an application as a 175.
Thought he was like done.
175 is a court document from the Circuit Court of Jackson County, Missouri. That's Kansas City. It was a guilty plea by William Mock. It says, on plea of guilty, defendant is sentenced to 6 months Jackson County Jail. Execution of sentence suspended. Probation 1 year. And so forth. Did you ever see a copy of that, sir?
It is my belief, I've never seen that before, and I can guarantee you that if I would have had that at trial, this is a document I would have used. Not only,
Go ahead. Oh, you don't answer?
I think to the question, they can ask the next question or not.
Do you remember in the deposition that you took of William Locke, shortly before trial, within a week or two before trial, you asked him whether he had ever testified before in a criminal case?
Yes, sir.
What did he say?
He said, no, I saw the deposition today. It's the only way that I would ever remember it. Although I swore to God that I asked him that question. It's just something I would have asked at the time.
That wasn't true, that we now know, right?
It doesn't appear to be from this docket entry or this exhibit, but I don't know if he testified or not or how all that worked out, but any of this information I would have used. And plus with the deposition answer, it seems to be inconsistent.
Do you remember ever asking him whether you have had any mental health issues?
It is my belief that I asked him at some point. I can't say that I remember specifically whether that was in cross or in the deposition.
And do you remember him saying, no, he didn't have any mental issues?
That is my recollection.
This information that we've just shown you today, now, you knew about this before you came to the hearing today, right?
Which information?
The fact that that Mr. Elking received payments,
Yes, sir.
that his traffic tickets were dismissed,
I believe I have seen that in the last couple of years.
that he had an extensive criminal record, which you didn't know about.
That is my belief that I saw that document and that he has
That he
a
had, that he
criminal history that I did not know about. Yes.
had in fact testified in a criminal case, and in fact had been in a mental institution for a while.
Okay.
With
I
all
had
of
been,
that- With all of that, well, you've used all of that in your cross-examination.
yes, but I will say I had been told that he had testified before. I could be wrong, sir, but I don't know that I have ever seen this document of the guilty plea in Jackson County. Somebody could have shown it to me before. It wouldn't be impossible, but I don't think I'd ever seen that before today.
What's the exhibit designation on the Jackson County?
What did you say? 175, Your Honor.
Thank you.
That's the William Mott guilty plea.
You have to wait till 3:30.
175.
But yes, they want always. Also, he wanted a treat that I had on my desk, but I didn't give it to him.
Going to hand you next. You prepared an affidavit last year or so in connection with the motion, or in connection with an effort to have the conviction of Lamar Johnson overturned, right?
I prepared an affidavit, I believe, at someone's request.
I'm going to hand you exhibit 17. So you have the affidavit that you prepared.
That dog was 175 pounds at one time. He had to go on a diet. So I'm 45 now, so he's good.
Yes, sir.
He likes to eat.
Your Honor, I have no further questions of Mr. David Bruns at this time.
Cross-examination? You may apply.
Well, George, I didn't
You
want
can
to
take that down if you wish.
or be crippled. He was overweight.
Good afternoon, Mr. Bruns.
Yes, ma'am.
You testified that it's your recollection you filed a motion for new trial. Part of the basis was these letters that you had learned about. Is that correct?
That's my understanding after seeing the motion for new trial.
Did you also, and that you were shown that before coming to court today?
No, actually, the first I saw any of that was after I was at court today.
Okay. Did you also see the motion that you had filed with the court requesting a handwriting sample of Philip Campbell?
I did not.
Do you have any recollection of filing a motion for handwriting sample of Philip Campbell?
I do not.
And do you recall at the motion for new trial that Philip Campbell would not authenticate those letters?
I don't.
Any reason to disagree with me that that's what happened?
Absolutely not. It is a blank slate. I just don't remember.
Okay.
And there's a transcript somewhere.
And ultimately, the motion for new trial that included the letters was denied. Do you recall that?
I know it was. Okay.
I'm going to show you a couple of documents that were part of the court file. Ask if you recognize these. I can approach, Your Honor.
You may, Counselor.
These are marked as State's Exhibits E and G.
Are you going to ask me about the contents of G?
Yes. Do you recognize them?
I'm going to read it then, but yeah,
Sure,
and all that. I'm sorry, I don't remember this at all.
I like how he just like stepped back and got comfy in his chair. I'm gonna sit back and read these for a little bit. I don't know these. Also, it's not really easy to get a new trial. I wish people would realize that. Judges aren't just like, okay, you got it, new trial.
Yes, ma'am.
Okay.
I've read them. I'm sorry.
And do you recognize those documents as filings that you made in the criminal case?
So,
We'll start with document labeled G, if you would.
Let me ask a question before you delve into that.
Sure, Your
I
Honor.
don't get what's on my mind. In your motion for new trial, there was a discussion between you and counsel that these letters were part of your motion. When they were part of your motion, did you argue them to the court as newly discovered evidence or evidence that had been hidden from you in violation of Brady?
I have no reason to believe that I ever would have argued that any of the letters were hidden. It is, and I could be wrong, I don't remember the letters specifically, but aren't they post-verdict letters?
Your Honor, I think I can clarify.
If the answer is yes, just say yes.
Well, I believe that they were alleged to be newly discovered evidence, but in the motion for new trial, since they weren't dated, I believe Judge Shaw said he didn't know if they were newly discovered.
Right, that makes sense. All right, thank you.
May I continue, Your Honor?
You may.
Thank you.
So can I say, okay, Exhibit G,
Yes,
that would not have been filed by me.
okay. Well, who would that have been filed by?
Hold on, can I see this exhibit that you said was not as filed by
Should
him?
be in your book.
You said G
G,
in this big old book you gave me?
I can
You have an extra copy of G?
An extra copy
I
of
warned you about this thing.
That's okay, let me see if I have it.
I warned you about this lots and lots of times. You should have just taken it back and tabbed it. So you ain't gonna look at your big old binder.
This one is not marked, but it is a copy.
But it is correct.
Yes,
And what was the exhibit number that would normally be on here?
it's letter G in the book.
It's exhibit G. Thank you.
G, like J.
Sorry, but I just need to be able to look at this. Give me just a second.
Sure.
Nancy.
I guess I should have said like Jay, but no. Yeah, I mean, everybody talks trash. It doesn't matter how they look. Everybody talks trash about other people. We're all terrible. See?
I think I'm beginning to understand the answer of the witness. It was not, to this day, it may not be unusual for, once a offender gets a hold of a typewriter while they're in prison, to generate filings alleged to have been filed by their attorney. Nor would an attorney file something and label it respectfully submitted and put their client's name down. They would only sign their own, and then they would designate attorney for defendant. So there's much here that supports the conclusion that Attorney Bruns would not have filed this.
May I inquire, Your Honor?
You may.
Mr. Bruns, would you be aware that if it was filed in a criminal case that you were assigned as the special public defender on?
Yes, out of our office, there would be virtually no filings that were filed except by the lawyer on record at the time, except for possibly an entry or a motion for discovery. Other than that, we were stuck doing our own.
So sitting here today, looking at that document, you have no recollection of ever becoming aware of a motion to compel being filed in Mr. Lamar Johnson's case?
This was not filed by me.
Okay.
And this was not, I'm certain by looking at it, it was not filed by a lawyer in our office.
And it's file stamped, so it would have been part of the court file, is that correct?
Yes, I mean.
Okay. And if it was part
Keep
of
in mind that at that time we kept paper files.
Sure.
So yeah, file stamped. I can see that. But likely would have been stuck in a big paper file. In the present system, you all have notice of things being filed through case Act. At that time, unless you were a lawyer who diligently checked the hard file every day, there could be stuff sitting in that file that you did not know was there. So be aware of the historical context of this document.
Understood.
And by this document, I mean Exhibit G.
And Your Honor, I would offer to move Exhibit G into evidence as it is part of the court file.
Accepted.
Thank you, Your Honor. And we'll move on to, I believe I handed you Exhibit E. And Your Honor, if that's in your report, we'll need to have a copy for you.
Or I can share with the judge. Do you have another? Yes. Thank you.
All right, in State's Exhibit E, are you familiar after reviewing it with that document?
Yes,
And what is that?
it's a notice of deposition, and I can tell you I filed it.
Okay, so that you recognize as you filing that in the case.
Yes, ma'am.
All right, Your Honor, I'd move to admit Exhibit E.
Admitted.
So, Mr. Bruns, whenever you were defending the criminal prosecution of Lamar Johnson, you received discovery prior to trial and depositions. Is that fair? At least in the form of police reports.
And I'm sorry that we got discovery before depositions.
And trial. You would have received the police report.
I would have received, right, the police reports and whatever. There'd be a lot of reports, police reports, lab reports.
If there were live reports.
If there were, I mean, anything that is generated, we at least ostensibly would receive them.
Okay. And so you would have reviewed those reports prior to deposing any witnesses in the case. Is that fair?
Yes,
And so whenever you took the deposition that you noticed up there in Exhibit E of secret witness and wife, you would have had read the police reports prior to that deposition.
yes,
And you would have known that in the police reports, secret witness was never identified. Is that fair?
I can assume that now. I have no specific recollection how all that was done, but it makes sense that I would have only known as a secret witness.
Okay. And in fact, you noticed the deposition up as secret witness and wife.
Yes,
And so you were aware that the identity at least was being concealed.
Yes.
Would you have any reason to disagree with me that the witness's name was redacted from the police reports over 100 times?
I don't remember, but that would be fitting with just how things were.
Okay. And that he was referred to as blank or witness or secret witness, does that sound accurate?
I don't remember blank, but secret witness is what I remember.
Okay. Would you like to review the police report and make sure that I'm accurate?
No,
No reason to disagree with me, sir?
no reason to disagree.
All right. And would it also sound accurate that in that police report, a number of times it's included in the narrative that the identity of this witness will be protected for as long as possible? Is that something that would be included in the police report?
I don't remember, and I don't generally remember things like that, but that sounds like something that Mr. Warren would have told me.
Okay. And so you were aware that Mr. Elking, who you later learned the identity or name of, correct?
Yes,
So you were aware that he was a protected witness in the police report prior to stepping in and being deposed?
I
That would have
believe
been
so. Yes, I believe that I knew that there was attempts to keep his identity secret.
Okay. And in fact, you took his deposition as well as his wife's, is that right? According to that notice, at least?
Absolutely, I'll accept it. I don't remember the wife at all.
Okay. And if you would have asked questions during either of those depositions that could reveal the identity of those witnesses, is it fair to say that there would be an objection and an off-the-record discussion?
That certainly could happen, but I'm gonna tell you is that and to this day, I think it serves everyone's interest that in documents like depositions, if there are concerns, I'm not into giving up addresses of any set of witnesses. It doesn't really help the defense.
Especially if they're a protected witness, right?
Well, it just doesn't help. And if that information becomes a necessity for some reason, there are different things that people can do. That you can say, you got to give it to lawyers, but you can get a protective order, that you can do things. The possibility of a witness being threatened in any way serves no one's purpose, whether it comes from the defense or anywhere else.
And so whenever you filed that motion or the notice of deposition, you expected that the state would produce that witness because it was in fact someone whose identity was being protected.
That is correct, and that's the other benefit, is that in depositions, is that it made the state much more likely to bring in witnesses for deposition for the defense without us having to go subpoena them.
Okay. And you testified, and correct me if I'm repeating this back to you wrong, but you testified that there's no benefit for anyone for a witness to be threatened. Is that?
It is my belief. It's just not part of the criminal justice system.
Sure. And so you've been a criminal defense attorney for about 30 years, is that right?
Yes,
And I'm assuming, sir, participated in multiple jury trials. I don't know if you know the number. If you do, I'd love to hear I'd love to hear it.
how about over 100?
Okay. And in those over 100 cases, you had the opportunity to cross-examine witnesses.
Yes,
And an important part of cross-examining witnesses, you have to consider the risk of what a question might do to open the door for further information on redirect. Is that fair?
yes,
Okay. And if a witness's identity is being protected and you inquire about that at trial, that could potentially open the door on redirect as to why that individual's identity was being protected.
it could potentially, depending what the answer is.
In this case, what could the answer have been other than the witnesses, that particular witnesses' protestations of personal fear that these individuals who did the attack might find out of where he is and hurt him? What goes beyond beyond that?
Your Honor, I think you just stated it, that it could
All right.
potentially come back
And
that
in the
he's
case
scared and
where
lied.
the defense is, it wasn't me, then that witness would have nothing to fear from the defendant. Wouldn't you agree?
If in fact that was the truth, yes, Your Honor.
All right. Then that being the case, all right, it seems to me that, I mean, obviously they were able to work this to where the witness's name did not have to be revealed. But I'm not sure if it's a high risk, low reward in cross-examination in this trial in the way you're suggesting to the court it could be. What I would prefer you to do is direct this witness, if you choose to do so, across this witness with a level of specificity that will allow the witness to tell you, well, on those facts, this is what I think the risk was. Because as this witness listens to me, he may be saying, Mason, you're off the chart. If I heard any possibility of anything that a witness was afraid of my client hurting them, I would never want the jury to hear that. And he might say that. I just need to know what he's going to say, because I'm not sure I want to deal with this fact in terms of what I would do.
Sure, I
Go
can
ahead.
inquire, Judge. So in this case, Mr. Brunson, I know that you testified that your memory of the facts are a little foggy. It's been a long time. So in this particular case, we can agree that the witness's identity was being protected.
Yes,
And in the police reports that you would have reviewed, it indicates that at some point, this individual viewed an in-person lineup, did not identify anyone, and then said he could identify the person but was scared. That's all in the police report. Does that sound familiar?
that sounds familiar.
And then at some point, he had been informed that this was an individual who was suspected of other serious felonies. I believe the police reports indicate other homicides. Does that sound familiar?
Did the police report tell the secret witness these facts? Or they were just,
I believe
was
it's
it in the police
I believe
report?
it's just in the police report.
So we don't know if the witness, which we now know, of course, is not Edling, but where's my brain here? Elking.
Correct.
We don't know if he was told this, because what I got from his testimony, he knew of these two people having no idea who they were, no idea if they have any access to, if they even knew him in any way, but just wanted to get out of the area to avoid even the risk that he might be hunted, that people might be looking around for him, as opposed to a witness who says, man, they know exactly who I am. They know where I live, they know who my relatives are, et cetera, et cetera. That's a very different type of witness.
Sure.
And if you don't want to ask him how he would handle those two facts, that's fine, but you don't need to. But I'm letting you know me, I'm letting you know what's on my mind as this case unwinds so I can get some good post-trial briefing.
I appreciate that, Judge, and I want to make sure that I'm not giving false information to the court from my memory of Mr. Elking's testimony, so if you'll just give me 1 second.
Sure, double check it. You need water or anything?
No, I'm going to pick up all the exhibits I got.
No, okay.
He's not like the last witness where he's choking up there. I'm gonna pick up some more papers that he dropped all over the floor. Oh, so many binders. Come on, people. Like I said, I think this guy's honest. I think he was probably a good attorney for him. He worked with what he had. They didn't give him everything to work with. If he had it, he's been honest that he had it. If he didn't have it, he's been honest that he didn't have it. That's how it seems.
And Judge, I think that we have some inconsistent memory amongst ourselves of what Mr. Elking testified to. So I'm going to ask the question.
Okay, then I will look at the exhibit myself. I mean, not the exhibit,
The transcript.
but I'll go back on the test for that myself. Go
Thank you,
ahead.
Your Honor. We can at least agree that the police reports indicated to you that he was in hiding or that he was being protected.
Right, my understanding was he was, quote, going to be relocated somewhere.
Okay. And you didn't ever ask him questions about that relocation to your memory?
No, and so I would not have in the deposition, it's just not, I'm not going to try to find out, because it seems like, oh, you're trying to find out where he's at. And that, again, that sort of serves no purpose.
And so I guess my question to you, and maybe I was unclear before, is there also a risk associated with asking him that at trial about the relocation?
I wouldn't phrase it like that.
How would you phrase it?
I don't think I ever would in trial ask about, like, are you being relocated? You know, are you being moved?
Okay.
Because of this reason. It's different if like certain bills and certain things are being paid for. That
But as far
doesn't,
as relocation,
but as far as relocation, I don't think that I necessarily, I don't think I ever would, because you're afraid, yeah, I'm scared, you know, they relocated me because I'm scared the defendant's going to kill.
and that could be damaging to your case.
It is not one of the easier things to hear.
I don't think I have anything further, Your Honor. Thank you.
All right, find the microphone, sir. You
Mr.
seem
Bruns,
with it.
I am going to show you and allow you to look at it, and I'm going to ask you a few questions. I only have one copy, but this is a transcript in the Circuit Court of the Missouri, City of St. Louis, State of Missouri, before the Honorable Booker T. Shaw. And it is the transcript of the sentencing proceedings in which Mr. Dwight Warren was there and you were there. And it's dated September 29, 1995. And I want you to start on page 8. And I've highlighted the area that I want you to look at. And I want you to get that back to me.
You notice when they got this guy up on the stand, he didn't say where he didn't say where he lived. He said St. Louis area or whatever. He's not about the addresses or people giving out addresses. Like they typically ask, where do you live? 123 Main Street. Yeah, Roseanne, that's a tough one. I haven't watched it yet. I've listened to a little bit of it, but we shall see. I was in New York as well, right? I don't know. I'm not getting into it.
Yes, sir.
Yeah, what page, pages 8 through 10, right?
Yes, sir.
Does that refresh your recollection that you were trying to get those letters into the sentencing hearing, a motion for new trial?
Yes, sir.
And Mr. Warren says, the court asked, is Mr. Nakarato represents Mr. Campbell? Mr. Warren says yes, and he has emphatically said that he will not testify.
I wonder why they're so focused on her. And why does she look so worried? That's weird. We've not seen her. Is she in custody? No, they're sitting there for him, not her. Huh. They're very, very focused on her.
He will advise him, but that his client will not testify. Very fair statement, Mr. Bruns.
Yes, so Mr. Nakarato would have been the head of the city public defender's office or the first assistant at the time. And he, at that point, he probably would have, this had been complicated. I'm sure he would have taken over and been in, sort of in charge, because Philip Campbell was represented by his office.
So you were trying to get Campbell or his attorney in to verify those letters, right?
I was trying to get the letters verified. As I read it, I thought we stipulated that for purposes of the hearing that he wrote it. The letters were written by Campbell. We did on page 8.
Yes, sir.
And so I would have tried to get them to stipulate it to it. Then I would have tried to get Mr. Campbell to come in and actually to try to make any sort of record that there is.
When you exhibit 91, it shows that you in fact had filed a motion, verify the handwriting sample, right?
This was a motion for an evidentiary hearing
Okay, and then I'm gonna hand you that.
on newly discovered evidence.
And then I'm gonna send you to give you exhibit 62 next. That motion you filed?
Yes, sir.
So you want an evidentiary hearing on these, the letters that we've seen from Mr. Philip Campbell. You were trying to get a handwriting sample from Mr. Campbell, and you were trying to get those things introduced in the sentencing as well as a motion for new trial, right?
Yes, well, there, this I clearly went at it from two aspects. One, at the motion for new trial, wanting to have a hearing, and also there is a different set of law, or so I think, about newly discovered evidence. And that you have to bring, I know, at the earliest possible moment.
Right.
So we would have asked for that hearing. I would say at this point also, I'm sure my boss was involved. I don't mean this, but I wouldn't have come up with all of this.
So the judge on page 10, after all of that argument, very well. Your motion for evidentiary hearing to supplement your motion for new trial is overruled. Yeah. Very well. Your motion for evidentiary hearing to supplement your motion for new trial is overruled and denied. Also, together with the motion for new trial, right? So those letters were never gotten into any kind of evidentiary hearing, right?
They were not. At the motion for new trial stage.
So let me,
that I was part of.
you may or not remember this, but you filed a motion for new trial around August 4, 1995. And there was also a motion for evidentiary hearing regarding the letters filed the same day on August 4, 1995. You remember that you filed both an evidentiary hearing motion and a motion for new trial the same day?
No, I didn't remember any of this until I read these documents.
Okay.
I'm sorry.
That's it. And we just looked at the motion you filed for a handwriting sample, right?
Yes, sir.
And then do you know that subsequent to all of this, subsequent to this transcript and everything else that we just looked at, then they searched Mr. Lamar Johnson's cell and discovered those letters?
I would think it was after I filed the motion for new trial before sentencing. Is that correct? But I don't have any clear memory. That's the timing that would make sense to me. But that's looking back on it.
You know, you might not have asked about changing addresses, but if you had known that he was receiving payments, you would certainly ask about that, right?
Yes. So that's it's a different thing that someone is being relocated from where they live to the fact that their bills are being paid.
That's a different from the safety concerns of relocation, isn't it?
It is, because that's a material benefit. When you're just moving locations, it's because you're inconvenienced, because you're like because you're a witness to a crime.
Were you aware that Mr. Elking was struggling with drug addiction at this time?
Objection, Your Honor, exceeds the scope of cross-examination.
Actually, it doesn't overrule.
Were you aware Mr. Elking was struggling with drug addiction at this time?
Well, I'm not sure what you mean by being aware. It's not like that I was like present when he was,
Right.
but like in my heart, I
You
mean,
can
I knew
reword
it.
You can reword. I think you would like to reword. so
Sure.
reword.
Did you have any information that he was having any problems with drugs?
During this whole time, that it's the only explanation about why he would have been where he was. It was known that Marcus was selling drugs, and not that I think that there's,
Sure.
that just sort of is what it is. It's not, it certainly has no reason to get shot or anything like that, but it is, and that would explain why he was there. And it was known to me that he had a drug problem.
Did you have any information, Mr. Bruns, that he and his family were financial difficulties?
I don't remember that. I know that, I just know from where and how this all was, is that they didn't have much money. No one had much money in this. I mean, nobody did. Philip and Lamar were represented by public defenders. It was, none of this was, and none of this was, there's no feeling of like any real drug money or anything out of this.
Mr. Bruns, thank you very much for coming here today. We appreciate it. I have no further questions at this time.
Anything further from the Office of the Attorney General?
No, Your Honor, nothing further. Thank you.
Hold on. I'm thinking about a question I might want to ask you, so give me a moment.
Yes,
Trustee,
sir.
I have a question. Would you, sorry, he's wagging his tail and hitting the wall.
It's a question that I'm thinking, can I answer myself, or had you known about the payments, the money that the state's key witness was given, together with what you opine, I think reasonably, that he was likely on that porch in an attempt to procure drugs, would you have taken the two and argued to the jury that part of his motive was so he could get money in these various payments for the purpose of procuring more controlled substances? You can tell me, no, I never would have tried that. I just want to hear where your head is.
So this is, I don't, the motive might have been payment to use the money for whether it's controlled substances or anything else. It's the payment of money because you need money whether you want to get high or to live or to buy groceries or if you have a wife and kids. It's the fact that everybody wants to have money coming in. And that's a motive to do something. I don't know that I would have made the extra leap that it's necessary to go get drugs. I don't know that I would have gone that far, but I would have gone that, you want to do things, and like we all do things to make money.
All right. I appreciate the
Judge,
answer
I
because you were in the moment, and that's why I wanted to hear what you had to say about it. All right. I'm assuming nothing further with this witness?
Correct, Your Honor.
You may step down now.
Thank you.
So we have a couple more witnesses, Your Honor. I don't know if you want to start them tonight or not.
Well, we're looking at 10 to 5, so
Yeah,
I guess that pretty well nails. That's right, 10 to 5, yeah.
10:05.
I think that pretty well nails that decision.
So we should be finished with our direct tomorrow, certainly.
I was going to say, tomorrow, we're going to look at He's being very rude. One more witness. Ooh, maybe. Sorry, I'm looking at my time. Because I'd like to stop to when Mr. Johnson takes a stand, and then because he's on the stand for quite a while, maybe. No, 10 till 5. Are you kidding? Not 10:05 at night. They thought 9 o'clock was midnight in the middle of the night. No. 10 till 5. Judge is like, that's enough. I'm trying to figure out, let's see. I think, no, I don't know who their next witness is. Let's go check it out. Because it's a long, long day, but there's big, long breaks in it. But I don't have time to do it all right at this moment.
Case.
Like, judge, 45 minutes just to get on the stand. Oh, it looks like the first witness is, looks like this witness is Mr. Elkin's ex-wife. The eyewitness, the other eyewitness, the one, I think she was in the, I don't remember, well, we'll find out if she had went into the house and I think she was in the house when everything happened with their 1-year-old. And then she, because she called, I believe she's the person who called 911. So we should be able to get through hers and then do Mr. Johnson's on Wednesday. And I may be back. I don't know if I'm gonna do it live or I may just upload it. It's not very long, but I don't have it ready. You remember the Daniel Garcia trial? Horrible guy. We saw the video of him tearing this little boy down the stairs. The one that whose mother said he wanted to be, she took him to Colorado and gently lowered him down the side of the mountain. She was, I think, sentenced last week on Friday. Of course, I was busy Friday. So I don't know if I may just do it and upload it later, or I may go do it live tonight. I'm not sure. So just be watchful, but I am going to do that because I want to get it done. I haven't watched it, but I'm not sure that there wasn't an issue there of some sort. Surprise. Unfortunately, she didn't get as long as Katrina Mendoza did because of her plea deal. We'll do story. Just depends on what time my husband leaves to go over to Brandon and Breeze. On how I do it. Because I know
All right. Division 17 is now in session. Pursuant to the term, I will date to see make sure it's compliant. Good morning, guys. Good morning, Bailiff. You may all be seated.
Tell you, he wheels up to that out of that magic door. Hello. Pretty much, I forgot that he thinks that gavel
I
down.
believe we moved over to your side of the case. We haven't already yet? All right. It's a little confusing. Counsel, for Relator and the Circuit Attorney, you may proceed with further evidence.
I'll let you know either way, Tony. So I've never seen the bailiff bang the gavel.
Do you solemnly swear that the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth, so help you God? Please give your name to the court reporter, please.
Was that OW or AW? OW, okay. Counsel, you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
Could you please state your name for the record, please?
Erica Barrow,
When were you born, Ms. Barrow?
June 3rd, 1976,
So how old are you right now?
46.
Could you briefly explain your educational background, Ms. Barrow?
I have a master's plus 30 with a degree in school administration.
When you say a master's plus 30, could you explain what that means?
I have higher than just a master's degree.
Okay. And your master's degree is in
Is
what?
in education.
Are you currently employed, Ms. Barrow?
Yes.
Where are you employed?
Special School District of St. Louis County.
What do you do for the Special School District of St. Louis County?
I am a special education resource teacher.
And can you briefly explain what a special education resource teacher does?
So for students that qualify for special education services such as reading, writing, math, in the academic area, along with task-related skills, I just service them for the extra help in the gen ed setting.
And how long have you been a special education teacher?
I've been in education for 20 years, special education teacher. I think this is my 10th year.
Thank you. Do you have any children, Ms. Barrow?
Yes,
How old are your children?
28 and 19.
And it's my understanding you've also been a foster parent as well. Is that correct?
Yes,
How long have you been involved as a foster parent?
14, 15 years.
Do you know Lamar Johnson?
I do.
How do you and Mr. Johnson know each other?
We dated. We have a daughter together. We were in a relationship.
When did you and Mr. Johnson first meet?
Spring of 1992.
And so in the spring of 1992, how old would you have been?
16. 16.
So you were just a kid.
Yeah.
How long did you and Mr. Johnson date?
2 years.
And were you and Mr. Johnson ever married?
No.
After Mr. Johnson was convicted, did you ever remarry? Or did you ever marry, I should say?
Yes.
And when was that?
January of 2002.
How long did you stay married?
2.5 years.
Over the years, have you stayed in touch with Mr. Johnson?
Yes.
And you said he's Kira's father, right?
Yes.
When was the last time you visited Mr. Johnson in prison?
It's been a while. I think the last time I saw him in prison, Kira was 14.
And you said she's 28 today?
Yes,
So it's
think
been
that's
about
right.
14 years since you visited him in prison.
Yes.
How many times did you take Kiera to see him in prison?
I believe that was the only time I took her to take him.
I'm sorry.
I mean, I took her to see him.
How many times?
I think that was the only time when she was 14
Oh, the only time.
that
when she
I
was-
took her.
I got you.
Yes. I did take her when she was younger, when he was still in the city of St. Louis. I'll say that.
Thank you. I want to go back to 1995, Ms. Barrow. Do you remember testifying in Mr. Johnson's criminal trial?
Yes.
How old were you when you had to testify?
18.
You're 18 years old,
Yes.
and by that point, Kiera had been born, right?
Yes.
How old was Kiera at the time?
I'm sorry. Testifying. I guess I was about 19. Maybe close to a year.
Before that trial, had you ever had to testify in a courtroom before?
No.
Can you describe to the court how you felt that day?
Very nervous.
And why were you nervous?
I had never been in a courtroom before. Just speaking in front of people, the situation that had taken place.
Do you feel differently now?
Still a little nervous, but not as nervous as I was back then.
Are you confident that you can tell the court what you remember to the best of your ability?
Yes.
28 years have passed, haven't they?
Yes.
A long time. Do you remember the day Marcus Boyd died?
Yes.
Why do you remember that day?
Just the fact that Marcus was murdered, and how we found out.
Is that something that's stuck in your memory?
Yes.
So back at the time Marcus Boyd died, do you remember where you lived?
I lived with my mom on Broadway.
And who did you live with at the time?
My mom.
And was your baby also living with you?
Yes.
Do you remember whether you ever spent time with Mr. Johnson at his place?
We lived together right before that.
Okay.
Yes.
All right. So let's go back to the earlier part of the day that Mr. Boyd died.
Okay.
What do you remember happening earlier that day?
As normal, I went to work. Normal work day.
I don't want to cut you off,
Okay.
so I'm sorry. Where were you working at the time?
Edgewater Nursing Home. Edgewater Nursing Home.
Where is or was Edgewater Nursing Home located?
South Broadway, a few blocks from 55.
On the same street as your mother?
Yes. Well, same street, opposite side of the street.
Thank you.
Mhm.
What did you do at Edgewater Nursing Home at the time?
A laundry attendant.
Okay. What type of shift did you have?
12-hour shift, 6 to 6.
Okay. At this time, Kiera was born, right?
Yes.
Okay. Who watched Kiera while you were working?
My mom.
I think you just said that your shift was 6 to 6. Do you remember when you got off work? Was it daytime or nighttime?
It was night.
Where did you go after your shift?
To my mom's house.
How did you get to your mom's house?
I walked.
Approximately how long of a distance was that to walk?
7 to 10 minutes. Not long at all.
So then I assume you arrived at your mother's, right?
Yes.
How long did you stay at your mother's?
Not long. Less than an hour.
When you left your mother's, how did you leave?
Lamar picked me up or picked us up.
Do you remember whether Mr. Johnson came inside or not?
He didn't.
Okay. So you were in your mother's house. Did you just go meet him outside?
Yeah.
Okay. So at your mother's, Lamar's driven up outside. You get in his car?
Yes.
Okay. Where did you, oh, I should ask, did you bring the baby with you?
Yes.
Okay. So you and the baby got into Mr. Johnson's car, correct?
Yes.
Okay, 100% don't know where she's going, where he's going. I'm wondering if she was with him at the time, if they're going to go down the path that she was with Lamar Johnson at the time the incident happened, so he couldn't have been there. I don't know, because I'm trying to figure out why they put her up here. Um, I know it's probably a stupid detail to get I'm not hung up on it by any means, but if the judge overturns his conviction and vacates that, given the age that he is now, I'm glad he was able to have a daughter, or it would have been a son, would have been fine too. Not like anti-guy by any means, because he's been in prison for 30 years approximately. So I'm trying to put this gently because I'm older. The best days of his life they were spent in prison. The best years, not days. So he probably, not that men haven't come out and have kids later in life, but he just, you know what I'm trying to say. I'm going to stop talking now.
Then where did you go?
We went to Anita and Robert's house.
Do you remember whether you potentially stopped at 1112 Rutger?
That was our old address.
So you don't think so?
No.
Okay. You just said that you went to Anita and Robert's house. Who are Anita and Robert?
Friends of Lamar.
What is Anita's full name?
I never knew her last name.
Okay. Did you know Robert's last name?
No.
Okay. So you went to Anita and Robert's house. Where was that house located?
39th and Lafayette.
And I think you just clarified this, but were they your friends or Mr. Johnson's friends?
They were his friends.
Okay.
Yeah, just mutual.
Was it one of those things where you're in a relationship and their friends become your friends?
Mm-hmm.
Okay. Did you like Anita and Robert?
They were fine with me.
Can you remember their home at 39th and Lafayette?
Yeah, kind of.
Okay. What do you remember about it?
I remember they stayed on the second floor. You had to go up the initial concrete steps, and then once you entered their door, you had to go up the stairs. It was on the corner, and there was a store like right below them on the very corner of the street. I don't know if it was attached or not. I can't remember.
I'm sorry, could you repeat that last answer?
So they stayed in a family flat,
Right.
and they stayed on the top floor, and so there was a store like right there at the corner
A store at the corner?
of the building, the apartment building. But I'm not sure if it was attached, but it was just like closely together.
I got you. Thank you.
You say that there was this store that was right there on the corner. What type of store was it?
Like the neighborhood convenience store, liquor store.
Okay. Why did you go to Anita's and Robert's that evening?
Lamar was going to meet someone there.
When you say that Lamar was going to meet someone there, what do you mean?
He was going to make a drug deal.
At that time, did you know that Mr. Johnson sold drugs?
Yes.
Why did you stay in a relationship with him?
I didn't know initially, but as time went on, I learned, And by that time, we were together and I just accepted it.
And you were 18, weren't you?
Yeah.
Do you remember what time you got to Anita's?
Probably after 7.
At the time you reached Anita's in Roberts, had you been separated from Mr. Johnson since he had picked you up from your mother's house?
No. Not, what do you mean?
Yeah, had you been with him the entire time?
No, he left like once we got there. He left a little while later.
And we'll get to that in a moment.
Okay.
I'm just talking about, you get picked up by Lamar from your mother's, right?
Right.
And then you remember that you went to Anita and Roberts, right?
Yes.
During that time that you were traveling from your mother's house to Anita and Roberts, were you with Lamar the entire time?
Yes, we didn't separate.
Sitting here today, can you picture yourself driving up to Anita and Robert's house?
Yes.
Where did you park?
Right in front of the building.
Did you park on the same side of the street or the opposite side of the street?
Same side.
So you arrive there, you park the car, and I know this is not a very interesting question. What did you do next?
We arrived, parked the car, we got out, went into the apartment.
Okay, so you walked straight from the car to the apartment.
Yes.
All right. What do you remember doing once you got into the apartment?
I sat on the sofa. Anita and I were talking. She was watching a movie. I sat down, started watching the movie. The guys went on through the house and were back off in the back room. And that was it. And
You say that you remember that Anita was watching a movie.
mhm.
Do you remember what type of movie she was watching?
It was a Lifetime movie.
So one of those cheesy ones my wife likes?
Probably.
Okay. What do you remember about what Mr. Johnson did
Lifetime.
while you were at Robert and Anita's? And I'm just talking while you're actually in the house. I think you said you went to the back room.
Mhm.
Do you remember anything else?
No, it was just like they were just back there talking.
You know, we finally get a witness we can hear and we can't understand her. Or at least I can't. She sounds like she's eating the microphone, which we've been waiting for people to do all day. Ugh. Audio in courtroom should not be so hard.
That was it.
So it was boys with boys, girls with girls?
Yeah.
Okay. At some point, did Mr. Johnson leave their apartment?
He did.
Okay. Did he say where he was going?
No, I mean, the reason we went was so that he can meet someone. So I just assumed that that's what that was about.
And once again, when you say that you were going to meet someone, you understood that he was going to sell drugs to someone?
Yes.
Do you remember saying anything to Mr. Johnson when he was leaving?
Nothing. He asked me if I wanted something from the store. That was pretty much it.
As you're sitting here today, can you picture Mr. Johnson in your mind when he was leaving?
Yeah.
And I saw you're just closing your eyes. Are you closing your eyes to try and help you remember?
Yeah.
What do you remember Mr. Johnson wearing as he was walking out the door?
White t-shirt and dark bottoms.
Did you watch him go out the door?
The door was right there next to the sofa. So, yeah, I saw him go out the door.
Did anyone leave with Mr. Johnson?
Robert?
You said Robert left with Mr. Johnson?
Yes.
Okay. So who remained in the apartment?
Anita, the baby, and myself.
When Mr. Johnson left, did you ask him who he was going to see?
No,
You didn't ask him about those types of things?
no.
Do you know the exact time Mr. Johnson left?
I mean, we got there at about 7. It couldn't have been after 8 o'clock. We hadn't been there that long.
So Mr. Johnson leaves, the door closes, right?
Okay.
What did you do while Mr. Johnson was gone?
Change Kiera,
Change Kiera?
change her diaper.
Okay.
Mhm.
You changed the baby's diaper,
Yes.
right? I assume that you went through the normal process of how to change a diaper, right?
Yes.
When do you remember Mr. Johnson coming back?
By the time I picked the baby up, he was coming back up the steps. It was after I changed her diaper.
Could you explain what you mean that by the time you picked the baby up?
So once I picked her up off the sofa from changing her diaper, he was coming back into the house, he and Robert, laughing and talking. And
Could you hear them outside before they came in the door?
no,
Okay. Did you see Mr. Johnson come back inside?
yes,
Did he come back in different clothes?
no,
To the very best of your memory, how long was Mr. Johnson gone?
5 minutes.
Ms. Barrow, did you know Marcus Boyd before he died?
I did.
Could you describe Mr. Boyd to the court? What was he like?
He was a funny guy. He was very down to earth. He had a positive attitude, friendly. Yeah, he was a good guy.
When was the last time you saw Mr. Boyd before he died?
The last time I can actually remember seeing him, Lamar and I had picked him up, he and Leslie, his girlfriend, and we all went grocery shopping.
Do you remember where you would have gone grocery shopping?
I want to say it was the Schnucks that was right there on South Grand.
All right. But both couples went together?
Yes.
Was everyone getting along?
Mhm. Yes.
Where did Marcus live?
Louisiana.
I cannot
Had you ever been to Marcus's home?
Yes.
hope you guys
How many
can.
times had you been there?
Several. A bunch. Like,
Several, a bunch? I mean,
we had gone there a lot. We had actually gone with Marcus when he was just looking at the apartment.
okay. Can you describe the nature of Mr. Johnson's and Mr. Boyd's relationship?
They were close. They were more like brothers. Lamar had actually lived with Marcus once, I think right after he had gotten shot for a while, and Marcus helped him out. They were really close
How long have you lived in St. Louis, Ms. Barrow?
all my life.
Are you familiar with the roads in South City?
Well, happy anniversary tomorrow. Good job. Mine is coming up on the 27th. And I am hoping Miss Madison is going to be born on the 26th. We shall see.
Yeah, pretty much.
So you know Grand and all those other roads that are in there?
Yes,
You know Louisiana,
yes,
you know Lafayette,
yes,
you know Shaw.
yes.
I'll get back to that in a second.
Okay.
Let's go back to Anita and Robert's home for a moment.
Okay.
After Lamar came back, what do you remember happening later that evening?
We were all just in the apartment. Lamar had received a page and he went to use the phone. I remember him picking up the phone and walking toward the back of the house. It was Pam, his older daughter's mom, calling him to say that Marcus had been killed.
How would you describe Mr. Johnson's behavior after he got that call?
It was like he was in disbelief. He was upset. Pam had told him that Leslie told the police that he had killed Marcus.
As that happened, did the thought cross your mind that Mr. Johnson might have killed Marcus Boyd?
Absolutely not.
Why not?
Like I said, they were close. They were like brothers. Lamar would have never done that.
And you've also testified that you knew how long he had left the apartment.
Yes.
Based on your knowledge of how long he was gone and the distance from Marcus Boyd's house to where you were, was it possible for him to have gone that distance in that time?
No.
And in fact, was it possible for him to have gone there, committed a crime, and come back in that amount of time?
No.
I think you testified that it was.
Be advised, there wasn't an objection, but I am taking that as somewhat on the speculative side. Didn't quite get the foundation that I would like to see.
And I would invite the court, if you have any questions, obviously, from Ms. Farrell, we welcome them. After that call came, what happened next?
Everyone was just in disbelief. I remember asking Lamar, why would Leslie say something like that? Just those normal questions. What happened? He was upset. He was pacing the floor. He was saying stuff like he can't believe this. And we left shortly after that.
When
Hold on a second, can you remember, and I'm not saying you should, but can you remember what time you got a call saying that Mr. Boyd had died?
I don't know.
This call, whose telephone did this call come over?
He used Anita and Robert's house phone.
Okay, when you say house phone, is that what they call a landline or was it a
Yes,
cell
sir.
phone? Landline.
Landline.
I don't think there was a lot of cell phones around in 1994. Some.
So then you said you left Robert
Six.
and Anita's. Where did you go next?
Lamar took me back to my mom's house.
Do you know exactly what time?
I don't know the exact time.
Did you go anywhere after that?
No.
Throughout the evening, from the time that Lamar Johnson picked you up at your mother's house until you got dropped off at home with the baby, how long had he been outside of your presence?
Just that 5 minutes.
Ms. Barrow, you're aware that Mr. Johnson identified you as his alibi before trial, right?
Yes.
I want to make sure that I ask this. Before Mr. Johnson's trial, did anyone from the police ever contact you to ask you any questions about Mr. Johnson's alibi?
No. Not police. I did speak with the public defender that represented him.
So you spoke with Mr. Johnson's attorney,
Yes.
But no police detective
No,
ever contacted you?
no,
Never
Oopsies.
called you on the phone?
no,
You never heard secondhand that anyone was looking for you?
no.
Ms. Barrow, other than outside in the hallway, how many times have you and I met?
Once?
Have I promised you anything in exchange for your testimony?
No.
Do you remember what I told you about truthfulness?
Just be honest.
Ms. Barrow, in a moment, the Attorney General's going to have an opportunity to ask you some questions. And I don't know whether they're going to spot any differences in your testimony now versus 1995 or not. When you're an 18-year-old woman versus a 46-year-old woman.
You're going a little deep.
Okay, thank you, Your Honor. What's your response about your testimony today and any possible differences?
Okay, don't answer that question.
That's fine, Your Honor. I think that's it for me, Your Honor.
All right. Before you inquire, I just need some.
Because he knows that's the only place they have to go with her is her prior testimony, because it's really the only place they have to go with anybody. So he was just, it's not like he had to head that off because there's no jury. So I really don't know what he was doing there. But I'll be curious to see what they ask. I'm sure they're going to have inconsistencies with today and 30 years ago. Tell me you remember what you said 30 years ago when you were 18. I was not 18 30 years ago, unfortunately. All right, let's see what this judge has to say.
Clarity on some things. Okay. Now, what was the address of Anita and you said at Robert's apartment?
Yeah.
What was that address? If you can remember?
I don't know the exact address, but it was right on the corner of 39th and Lafayette.
On the corner, you said 39th and Lafayette?
In Lafayette.
Hold on for a second, just a second. And what is the address at the place where Mr. Boyd died?
That would be 3910 Louisiana.
Louisiana. And how close, from what you can recall, is 3910 Louisiana to the home at, the building at 39th and Lafayette? You can do it in blocks, half blocks, several blocks. So how close do you think it was?
It's a couple of miles. It's not close. It's a few miles. It's not.
Did you say a few miles?
Yeah.
Yes.
It's a few miles.
Is that accurate?
Yes.
All right. I assume you've checked it out already.
I've driven it many a time, Your Honor.
All right. Well, a few miles is a bit of a distance. I'll stop right there. I don't think I have any more questions. Go ahead.
That was it for me,
I'm
Your
sorry.
Honor.
Counsel for the Attorney General's office, you may inquire.
Thank you, Your Honor. Good morning, Ms. Barrow.
Good morning.
You testified that on October 30th, 1994, the day that Marcus Boyd died, that Mr. Johnson picked you up from your mom's. Is that correct?
Yes.
And you testified on direct examination that that would have been sometime prior to 7 o'clock,
Yes.
and that you went from there straight to Anita and Robert's house.
Yes.
And they were living together at Lafayette.
Yes.
And I think you testified on direct that that address was 3910 Lafayette. Was that, did you misspeak?
Yes.
Okay, you don't know what the house number was?
No. I mean, maybe back then, but No, no.
And you testified that the reason that you went there was because Lamar planned on meeting a friend who was a few houses down on Lafayette, close by.
No. He was planning to meet someone. That's all I knew.
Okay. And you testified at trial back in 1995, is that correct?
Yes.
If I may approach, Your Honor.
Yeah, man.
I'm going to show you page 312 of the trial transcript, starting at line 3. Just have you read along with me. Can you see it? Sorry.
Yes.
Why did you go to Anita's? Answer, because he was going to meet somebody. Answer, he was going to meet somebody next door to Anita's house, so he decided to go up and visit. Did I read that correctly?
Yes.
So to be fair to say that he was going to meet someone that was on the same street as Anita?
I can't say if that person lived on the street. All I know is that he was meeting someone there.
Okay, so someone on the street, but maybe not someone who was there, that wasn't their residence
Yes.
necessarily. And he didn't tell you who that person was?
No.
You didn't ask?
No.
But you knew it was to conduct some sort of business, some sort of drug deal?
Yes.
And whenever you were at Anita and Roberts, and I'm just going to call that the house on Lafayette, is that fair? You know what I'm talking about?
Yes.
Okay. When you're at the Lafayette house, whenever Mr. Johnson left, you weren't watching him out the window, is that fair?
No.
You weren't looking at your watch timing him, is that fair?
Yes, that's fair.
Were you even wearing a watch?
I don't know.
Okay. Didn't have a stopwatch starting and stopping when he was leaving and coming
No.
back? All right. And you testified that you don't know exactly what time you got to Anita's. Is that fair?
Yes.
Don't know how long you stayed there?
About 2 hours. I mean, it wasn't a very long time. We had gotten there, I know it had to be after 7. And then he left, he came back shortly after that, he received a phone call. I think once everyone was calm, then that's when we left.
Okay, but you don't know what time that was. You can't remember.
No.
And you don't know personally what he did while he was outside of that house. I think you testify on direct that you assumed he was making the drug deal.
Yeah.
Okay, but you can't say with any certainty what he was doing. Is that fair?
Yes, that's fair.
In the summer of 1995, in July of 1995, you recall testifying at the original trial for Lamar Johnson.
Yes.
At that time, was he still your boyfriend?
Yes.
And at that time, you had been together about 3 years. Is that fair?
Yes.
Prior to his arrest, immediately prior to his arrest, were you still living together or had you moved out?
No, we had moved out.
Okay, but you had lived with him at some point prior to that night.
Yes.
You had a baby together.
Yes.
Someone that you cared about very much.
Yes.
And still care about to this day.
Yes.
He's the father of your child.
Yes.
Because you were in a relationship, even if you weren't living together, would you communicate, whenever you guys would get home at the end of the day?
Yes.
Would you stay together even when you weren't living together?
No.
Okay. You would always stay in separate apartments. You would never spend the night together?
No.
No, you wouldn't spend the night
No,
together?
we wouldn't.
Okay. But you were aware that he was arrested and didn't come home after a few days. Is that fair?
Yes.
And at that point, you became aware that he had been arrested for the murder of Marcus Boyd.
Yes.
You communicated with him when he was in jail?
Yes.
You testified on direct examination that you would take your daughter to visit him when he was in St. Louis still. Was that prior to his trial, or did you go visit after, or both?
Both.
Did anybody here get the visitor logs for Mr. Johnson while he was being held? I guess it would have to be in the last year. Does anybody check those visitor logs by any chance?
When you say in the last year, Your Honor, you mean in
From today?
No, I don't. We have, I think we do, Your Honor. I'll check at a break if that would please the court. May I continue?
You might want to introduce that. I do this because I might have some fact questions, and I want to make sure I get all the evidence to resolve any fact question I may have.
Sure, Judge. We'll get that marked and offer it to the court. May I continue? Your Honor, may I continue the inquiry?
You may, counsel.
Thank you.
Sorry, yes.
And so whenever you became aware that Lamar Johnson had been arrested, did you talk to him at all about that night?
Yes.
And you realized at some point that you may be important in that trial.
Yes.
And whenever you realized that you may be important, you never on your own called the police to say Lamar Johnson was with you. Is that fair?
I was 18. I didn't know.
So is that a no?
No.
And you never called the prosecutor, the circuit attorney's office
No.
to talk to anyone? And you never called Lamar's attorney. In fact, he contacted you. Is that fair?
Yes.
And you didn't talk to his attorney until a couple of weeks prior to that jury trial. Is that fair?
Yes.
And someone picked you up, or do you remember how you got to his attorney's office to talk to him?
I think the first time I caught transportation, and then there was another time I was picked up.
Okay. And so you told his attorney that you were with him that night, everything that you could remember.
Mm-hmm.
And between the time of Lamar Johnson's arrest and the time that you talked to his attorney, that was the first time you told anyone related to the court or the case about you being with him that night. Is that true?
Yes.
And between that time, you were in communication with Mr. Johnson.
Yes.
You testified today that you went directly from your mom's house to the Lafayette house. Is that correct?
Yes.
May I approach, Your Honor?
Yes, ma'am.
I'm going to show you page 310 of the trial transcript. I'm going to have you read along with me starting on line 16. Make sure you can see it as well. Starting on line 16, or 17, I'm sorry. Question, after you got to your mother's house, did you leave your mom's house? Answer, yes. Question, what time? Answer, around 7. Question, how do you remember the time? Answer, that's the time Lamar's supposed to come and pick me up. Question, who picked you up? Going on to page 311. Answer, Lamar. Question, and did Lamar go inside the house? Answer, no. Question, after you got into Lamar's car, where did you go? Answer, home. Question, where was home? Answer, 1112 Rucker. Question, and where is that? Answer, next to the project on Shoto. I'm going to skip down to line 16 on that same page 311. How long did you spend in your house? Answer, maybe over an hour. Question, from your house, where did you go? Answer, on Lafayette. Question, whose house did you go to? Answer, Anita's. Did I read that correctly?
Yeah.
Start that, please.
So on October 30th of 1994, you couldn't have gotten to Anita's house at 7 because you went home for over an hour first. Is that correct?
No, we were at Anita's house for over an hour. By that time, I was living in my mom's house.
Did I read that correctly with you just now?
You did.
Okay. And you testified on direct examination that whenever you were at the Lafayette house, that you were watching a Lifetime movie, and that you noticed Lamar leave and that Robert went with him, and you and Anita stayed in the apartment.
Yes.
Is that correct? May I, Your Honor?
Yeah.
I apologize, Your Honor. Lost my page. Okay, I'm going to show you, I can search that.
You bet.
I'm going to show you page 320 of the trial transcript. And starting on line 18. Question, and he says, I'm going where? Answer, next door. Question, what did you do when he was gone? Answer, I sat and talked to Anita and Robert. Did I read that correctly?
You read it correctly, but Robert was not in the home. And again, I was 18. I was scared. I was nervous. I was
Ma'am,
confused.
you answered the question.
And so you testified today that while Lamar Johnson was gone, you changed your baby's diaper, and
Yes.
that's kind of how you were gauging the time. Is that correct?
Yes.
May I approach, Judge?
You may, Counselor.
I'm going to show you page 320 of the trial transcript starting on line 22. Question, how old was the baby then? Answer, about 4 months. Question, did you change the baby or feed the baby or anything then? Answer, I don't remember. Did I read that correctly?
You read it correctly.
And you testified today that, and I wrote it down, that he couldn't have been gone more than 5 minutes. Did I hear you correctly?
Yes.
May I approach, Judge?
You may.
I don't know how effective this is to tell her what she said 30 years ago.
22, question. But he said it could have been 3 or 5 or 7. Do you remember that? Yeah. Answer, yeah. Question, did you agree with him on that? Answer, yeah. Did I read that correctly?
You did.
Okay. So back whenever you testified in 1995, your memory was that it could have been more than 5 minutes. Did I read that correctly?
You read it correctly.
I have nothing further, Your Honor.
I mean, they had to, but
Redirect.
okay.
Your Honor. Yeah, why? 28 years is a long time, isn't it?
It is.
Are you testifying here truthfully to the best of your recollection after 28 years?
Yes, I am.
The Attorney General's office just went over a few items with you.
Okay.
Did they identify any time where you testified that Lamar Johnson had been outside of your presence other than those 5 minutes?
Did they?
I'm striking that question. If you're gonna
I'll
rehab,
rephrase.
go right at the Q&A that was done. Don't say stuff that really actually wasn't said quite the way you framed it.
That's fine, Your Honor.
Go ahead.
I'll just try and wrap this up in one question.
All right.
Sitting here today, is there any doubt in your mind that the only time Mr. Johnson was outside your presence was for those 5 minutes?
He was not.
Thank you.
Did you have any recross, Counselor? You may step down.
Ouchie. All right. If I can find my. So I'm going to stop that there because Mr. Johnson's going to take the stand next, and his testimony is long, and I want to be able to listen to it all. Hopefully we can hear him. Hers, like, sound is great and but muffled, dang it. So Wednesday we'll do his testimony. I'm trying to think. I was thinking I was gonna maybe start earlier, but then you know how that goes, right? If I can, then I'll just throw up the link. Oh, first day was horrible. And today's didn't start off good because that attorney is like, are you afraid? Are you scared of microphones? I just always say they're allergic because just get over to the freaking microphone. It's not hard. I want to get this wrapped up because I want to get to that trial in Atlanta that's going on. So we'll see how it goes. I will be planned to be back later again to do that. I can never remember that woman's name. Nicole Aguilar, to do her sentencing or whatever happened on Friday with that. I'm not sure. Not watched it. Just saved it, and I'll do it with all of you guys. So if anybody's going to be around, I can do it live. If not, I'll just upload it. It's fine. It's fine either way. I'll be fine. But I want to get it uploaded so that we'll get that all to no, August is his sentencing. So that's really what she's gonna get a maximum of 15 years. He's looking at life and he deserves it. Sorry. Oh yeah, Roseanne, that judge. I know I say it every time Delphi comes up. She was in the pilot program for the cameras in the courtroom, liked it, said it was great, and now has done a complete 180, doesn't want him around. Everything is already just absolutely a crap show in that case. The trial is going to be horrible. They're starting, when I read the comments locally around here, they're starting to lose support because when he very first was arrested and they started doing motions and hearings and everything like that, it was just guilty, 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 guilty in all the comments. Now it is very not that. It is very I wouldn't even say, the last time I checked comments, I wouldn't even say that it's evenly split anymore. I would say it's maybe 60-40 of not guilty, something shady's happening, to just put him in jail. Stop wasting our time. That's huge. So they're losing support. They tried to. That is something I was kind of had saved in the back of my mind because I get it. I'm not a lawyer, obviously, so I don't know all these procedural rules and everything, but I don't understand when you're asking, and it probably wouldn't matter anyway, but when you're asking a judge to recuse themselves, what do you think they're going to say? especially her. So she just denied that motion here last week, a week before. I didn't even have to. When I saw that they had asked, like, don't even need to read it. Don't care because I know it's going to happen. It was denied. Ooh, big shocker. You know, it is they're trying to keep all the stuff out, the prosecution is. And if if the Odinistic stuff or whatever that's called is so out there and so crazy, then let him bring it in. Who cares? If it's just such a crazy idea that this was a ritualistic unaliving of these two girls, then let him bring it in. Let him look crazy. Why are you going to fight to keep it out? I mean, I don't know. That's just where my thoughts go. I will, I'm always with, like, if the defense hides stuff, I expect, I expect them to hide stuff. But when the state wants to hide stuff, then I question. I'm sorry. I don't know who I'm telling. I'm telling you. I don't know. I mean, it just, it I'm not saying it's okay for either side to hide anything. You expect it from one, not the other. That's all I'm saying. This judge has been horrible. There's a lot of people that are even questioning uh, now the police work because they wouldn't let the FBI in, apparently. There's so much stuff, and it just reeks of they just want it closed and it to go away to say that they solved this crime. And it's kind of like what we're watching right now. They just wanted it to go away. Now, we haven't heard the state's evidence in this, but it it's what it feels like. Easy. He doesn't mean anything to anybody. He's just a drug dealer. He's just a stupid young kid. Who knows what his future would have been? The woman we just saw, she's made a great future for herself. So, who knows, or who knows what he would have done with his life? And now we will never know. It's the same with I told you at the beginning of this when we watched openings. It's the same with Ty. They looked at Ty as somebody who was homeless, even though he wasn't on illegal substances. They kind of made it seem like he was on illegal substances. So he was disposable. We can tie this up in a bow and get rid of him because nobody will care. Well, but people did, and now they do. And now it's like everything is just a crap show with that. But they're exposed. So, I don't know. I I agree with you, Roseanne, because there's a guy here in Indianapolis that was just exonerated. The family of the victim helped exonerate him. Took 30 years. Again, he was innocent. They found horrible police work. They found the police buried evidence. They found a bunch of stuff that they did horrible to just put this guy in prison. And they did it. They did put him in prison. Like I said, the victim's family was in. They helped get him exonerated. And now it was the victim's family, and there was several I believe like law schools that looked where the students would looked at that case to see like across the country that looked at it, that were just all of them kind of like, what happened? But sorry, my dog's snoring. Now they think they know who did it. That person has since passed away, of course. So, but they're trying to prove that this guy that they thought all along, that this people were saying all along did it. Witnesses were saying did it. Witnesses put the guy they put in prison across the street in a different building said he was not out there. He was not involved in this. They're trying to get that together and get that evidence together so that the victim's family gets justice. So I don't know if this guy that was put away for 30 years who was very wrongly convicted. I don't know if he can get money like you've seen in some of these other cases where they get millions of dollars, but that doesn't buy you your years back. It maybe makes your remaining years easier, but it doesn't buy you your years that you've missed back. It doesn't buy you your time with your family back, watching your kids grow up, or even having kids in some cases. It doesn't get any of that. So, and then some cases, they're not able to sue for that money. So I don't know. I don't know. That's why I'm always like, I just want to see the evidence. And I say at the beginning of every trial we watch, just be a clean trial, both sides, just be clean. That's really, that's all I want. Just be clean and be fair and present us actual facts and evidence of why you think this person is guilty or innocent. And stop with this other stuff. Yeah, they do think it is. I agree with you. Addiction is a disease. But they falsely flagged, kind of made us think that Ty was addicted to stuff, and he wasn't. He wasn't that addict that they made it look like he was. Because I remember Lauren asked me one time, why do you think he was a drug addict? And I said, because that's the way they portrayed him. Let's hang out at the treehouse. Why would you hang out at the treehouse? Or why would you be here or there? Why would you be homeless? Why? But he was not. He is not. Absolutely. That's very true, Roseanne. You can borrow money, you can borrow stuff. You cannot borrow time, and you can't get it back. There are no redos. Gabby, yes, I was talking about possibly doing a live tonight, or I may just upload it, that sentencing. It's not long. Like 10 or 20 minutes. It's very short. So I may just upload it because I know everybody's busy. And then I can just get it done. You want live? George, you'll be asleep. Maybe. Maybe not. I don't know what time you go to bed because it'll be like maybe 6 o'clock my time. All right. I will, as soon as Mr. Hamp leaves, I will get it going. One thing about time travelers. I make a joke about time travelers all the time when Todd and I are watching baseball because there's this person that sits at Yankee Stadium and they sit in the same place all the time. And he always wears sunglasses, day or night, doesn't matter. And I'm like, he's a freaking time traveler. He's got time traveler sunglasses. And then when they go play the Red Sox, there's this person that sits in the same place every time. I've seen them for 2 years now, both people. And always has sunglasses on at night. And I'm like, time traveler. My husband's like, you are crazy. I will put the alert up I will go actually, I'll get it ready, but I won't put I mean, it's gonna like go up shortly before I go on. So be ready. But I will try to make it around 6. So I will get, or Stormy, I will send you a message on Discord. Everybody else, I will put it up and put a time on it. Like I said, it may not be much notice. It'll be quick. Not like today. And I know that's what she said joke in there somewhere. I can't help it. You guys have cemented my mind a little bit. So, all right, I'll see you guys in a little bit and we will see what happens with this woman. I'm not calling her mom, not calling her that kid's mom. I am Eastern time, Roseanne. Yep. Indiana. I think it should be Central time, but they didn't ask me when they made us do daylight savings. Rude. All right, I'll see you guys in a little while. Thanks for being here today. And I'll see you in a bit. I'll learn to talk then too. All right, bye.